Good morning, everyone. Thank you for your patience. We were dealing with a Zoom technical difficulty, but I think we have it resolved. I'm Andrea Marsh, Director of the Mithoff Program at the University of Texas School of Law. I'm thrilled to welcome you to today's event, FDA at 20, Reflections on the 20th Anniversary of the Fair Defense Act. I started working on this event 2 years ago in my capacity as the Vice Chair of the State Bar's Committee on Legal Services to the Poor in Criminal Matters. Our original plan was for an in-person event at the law school. We had to scrap that because of COVID, and it took us a while to regroup, but I'm so glad that we made it here and are able both to commemorate the FDA's anniversary and to take advantage of the opportunity that anniversary provides to reflect upon the past, present, and future of public defense in Texas. As you'll hear later this morning, the FDA passed during the 2001 legislative session, but most of its provisions didn't go into effect until January 2002. So now that it's January 28th, 2022, we're getting this anniversary event in just under the wire. And I want to thank all of you for joining us this morning. I have a few housekeeping announcements before I turn things over to our opening speakers. After opening remarks, we will have 3 main sessions, one each on the past, present, and future of public defense in Texas. You can find a detailed agenda with timing and speaker information on the event website. I'll drop a link to that in a moment if our Zoom master, Kathleen Casey Gonmez, doesn't beat me to it. This event has been approved for 3.5 hours of CLE, including 1 hour of ethics. We'll provide the CLE code at the end of each session. We hope you can stay with us all morning, but we realize some of you may be in and out, and so we will provide that for any session that you're here for at the end of that session. We'll have some interactive elements in between some of our sessions, and we hope you will participate in those. You can do so either on your computer or with your phone, and we'll provide instructions at the beginning of the first interactive session about how to do that. And if you're into this sort of thing, our social media tag this morning is #FDA20. So let's get to it. We're starting with opening remarks this morning from Commissioner Rodney Ellis, followed by Judge Sharon Keller. In the interest of time, I'm going to provide just the briefest of introductions for our speakers. Commissioner Ellis is Harris County Commissioner for Precinct 1, where he plays an important role in decisions about how public defense services are delivered in Texas's largest county. Prior to that, he served 26 years in the Texas Senate and was the Senate author of the Fair Defense Act. Judge Sharon Keller is the presiding judge of the Texas Court of Criminal Appeals and has served on the CCA since 1994. She has been the chair of the Texas Indigent Defense Commission and its predecessor agency, the Texas Task Force on Indigent Defense, since they were first created by the Texas legislature. Good morning, Commissioner Ellis. Thank you so much for joining us, and I'm going to hand it over to you.
Good morning, and Andrea, thank you for inviting me and to give you some of the time back. I won't do what I was prone to do when I was in the legislature. I won't do a filibuster. It's good to be with my friend, Judge Keller. She's a tremendous ally on so many of these issues. I miss seeing her. I just ran through the list of some of the people who signed up, a lot of good friends. One in particular that I would pay homage to from New York, who was my staffer when this bill actually passed, Hannah Lieberman at the time. She's now Hannah Lieberman Dershowitz and still very active on these issues. So I want to give her a shout out. Just by way of background, when I went to the Senate in 1990, I had the good fortune of not having to have a big fight to get elected. Maybe nobody wanted the job. I'm not sure what it was, but we were lucky enough that the field was clear. And so we didn't have to spend money that we raised to campaign as hard as we thought. I had the backing of former State Senator Craig Washington, who was in Congress. I think that may have been a good reason why maybe I didn't have a tough race that I thought I'd have. So I told my staff, get our agenda together, because by God, I was planning on campaigning on an agenda, and I don't want people to know I was going to have to put that agenda together on the fly. So we had time to think about it during that special session. One of the issues that we opted to pick up on was the need for public defender offices in Texas. It's really because one of my lead staffers, Mark Strama, who later for Austin people became a state rep, Mark's sister worked for the public defender's office, I think, in LA or maybe in Baltimore. So it was one of the bills that we put in. It didn't go anywhere. Periodically, I'd ask for a hearing and members would kind of laugh. In the 1999 legislative session, the issue had become ripe, and we actually got a bill passed. Now, memory fades from time to time. I thought it was pretty much a weak bill because every time somebody had a problem, I made changes, a House or Senate member, and the bill passed almost unanimously. You can go back and check. There was an article in the Texas Observer that went through the bill that made the point that my memory was quite correct. It was stronger than I thought in 1999. But the main provision that attracted me to that bill and made me proud of it was it would have forced all 254 counties in Texas to meet, have some sort of a discussion about their indigent defense plan, and then vote on it. So I thought, and one of my advisors who's at Rural Legal Aid, you may know his name, send him the tape if he's still around in New Mexico now, I think. Jerry Wesovich was one of the people who would advocate to me when I was in the Senate to try to push the bill that I put in 1991 that never got a hearing until 99. Wesovich said if every county has to meet and talk, then at least it gives us a footing, maybe for litigation or at least a discussion so people would focus on the weak state of indigent defense throughout Texas in virtually all 254 counties, even the few that had state authorized public defender offices, like El Paso as an example, and a few others that had them, Dallas. So that bill passed in 99. Governor Bush vetoed it. I remember being at a bill signing for a sales tax holiday tax break bill at Old Foley's in Houston. And Governor Bush said, Ellis, I'm going to veto another bill that you have. So I'm glad you enjoyed the limelight today. I'm going to veto your fair defense bill. And he said, a lot of your friends in Houston have written letters to my office asking me to veto it. And so I was a little disheartened. And I did do an open records request to see who was writing those letters. They were the people who were getting the court appointments. That veto really created the impetus to pass this bill in 2001. Because on the presidential campaign trail, a couple of times, Governor Bush, presidential candidate Bush, was asked about why he vetoed that bill. And it was a difficult one to answer. A couple of states, in my mind, I think of the judiciary in particular in Georgia and in North Carolina. They stepped up encouraging more of a focus on indigent defense. And in the South, it was always a particular serious problem. I talked to the Chief Justice of the Texas Supreme Court at the time, Tom Phillips. Judge Sharon Keller was always an ally. Obviously, they had other issues that they wanted to push as well, like funding, technology, and a host of other issues. I assigned this bill to Hannah Lieberman to work on it on my staff. I think I was chairing the Judiciary Committee in the Senate at that time. I'm not sure. I think it was Judiciary. And then when Governor Bush won, just as the fate would have it, I looked up and became Senate Finance Chair, which is a very powerful position in the Texas Senate. And so I just gave this bill, the Fair Defense Bill, that we'd worked on quite a bit. It was a priority for us before I became Finance Chair, but I was so busy having to work on the budget. We had, as I recall, about 4 big bills. We had the hate crime statute in 2001. It was time to pass that in Texas. And the hot button obviously was sexual orientation in the bill. We had DNA testing. I'd gotten to know Peter Newfield and Barry Scheck very well over a famous case in Texas. Judge Sharon Keller, you remember that case? I think it was the McGinn case. And we had a bill to increase the compensation for people who've been wrongfully convicted in Texas, to move it up to about $100,000 I believe, and the Fair Defense Act. I think I gave the DNA testing bill that Hannah had worked up. We gave that to Senator Duncan, who was my partner on so many of these issues. Just a tremendous bipartisan coalition we had going. I think I kept the Fair Defense Act. I think I kept the hate crimes bill. I think I kept the compensation bill. But Hannah really did the work on this bill. We put caseload standards in it, all of the things that the experts on this call know about. We looked at best practices around the country. And two mistakes that I think I made in the bill. And 20 years later, 21 years after it passed, 20 years later after it went into effect, when you go to your thing said, here, the future, here are a few changes I would make if I could do it over again. I would have put in a stronger enforcement mechanism. And I would have made it easier to implement. I wouldn't have put in language where you had to have such a large majority of judges to sign on to do it, because it stifles the discussion sometimes. Or I would have made it a public vote. So at least you would know if someone did not want to move. That's not to say we haven't made progress with. Here's the last thing that I would do differently. I funded it. I was finance chair, but it was always a tight session. The challenge was going to be how to pay for it. And as a method of finance, the state was collecting some fees from indigent people, a number of court fees. It was always a big issue, because we make the cost of going into the courthouse to get justice so expensive with these various regressive fees. I took these fees that were being collected but not used. We call it sweeping a fund. I just took that money that was parked somewhere just so you could use it as a method of finance to balance the books for the state, because we have to balance our budget. I took that money, and that's how we fund the Fair Defense Act. I would have made a stronger case 20 years ago to use general appropriations, general revenue to do it. Since then, we have done some, but not nearly enough. I put my great talking points. I have great staffers now, like I had when Hannah was with me, and they prepared some talking points for me. But instead of me reading them to you, as you can tell, this new medium still drives me crazy. I'm accustomed looking up and looking down instead of looking to the side. Looking at this camera, I miss that interaction with people, particularly being a pot-bellied county commissioner now, not standing up on the floor of the Senate and giving a speech. But look at my talking points. It walks through specifics in the bill. And I couldn't find an article that I made reference to earlier that was in the Texas Observer that really did a detailed analysis of that bill that passed in '99 that was vetoed. Passed unanimously, I believe, in the Senate. Maybe one person voted against it in the House. But here we are, 20th anniversary, 21 years after the bill passed. We made tremendous progress, which you're going to hear the experts talk about. And you'll see in my talking points that experts on my staff came up with. But we can still do better. Thank you. And again, I'm glad to be with you. And Jeff Burkhart and so many friends.
Thank you so much, Commissioner Ellis. And we look forward to having you back in our past session, which is going to start shortly. We cannot put those out in the chat, those talking points, but we will send an email to participants with resources after this event. And now I want to turn it over to Presiding Judge Sharon Keller, who is also the chair of the Texas Indigent Defense Commission. Judge Keller.
Thank you. Good morning. And thank you all for participating. Hold on a second. In this event, marking the 20th anniversary of the establishment of what is now called the Indigent Defense Commission. My thanks to the William Wayne Justice Center for Public Interest Law at UT Law School for organizing this program, and my special thanks to Andrea Marsh, who has supported TIDC in so many ways for more years than I can count. It's really hard for me to believe that it's been 20 years since we started this project, but there's a whole generation of lawyers who don't know what the indigent defense system was before then. So let me try to explain. There was no system. As far as appointment of counsel, each county did things its own way. Each court within a county did things its own way. Same for payment of counsel. There was no consistency. There was no data collection by the state and not much by the counties. With the exception of a little bit of money for capital habeas, there were no state funds for indigent defense. Counties paid for everything. There was no good way to tell if people were getting counsel promptly or if they were sitting in jail, or whether when they did get counsel, their lawyer was qualified. There was no state oversight of any of this. Then in 2001, Senator Rodney Ellis's Senate Bill 7. With his bill, the legislature established the Task Force on Indigent Defense, effective January 1st, 2002. Under SB 7, for the first time, counties had deadlines for appointment of counsel. The bill required countywide indigent defense plans and objective criteria for determining indigence and objective qualifications for appointed counsel. And importantly, for the first time, counties were required to report information to the state. The bill actually required counties to have indigent defense plans the moment the bill took effect, so we had to get a jump on the effective date of the bill. Jim Bethke worked for the Office of Court Administration, and he was assigned to do that. He held a number of meetings in 2001 with people who were involved in indigent defense, and he was hired as director. And he assembled his tiny little brand new staff. And even before hiring staff, we had to figure out what jobs needed to be done. Do we need to hire somebody to be in charge of data collection, somebody to monitor money paid to counties, an executive assistant? We made these kinds of decisions every day. I think Jim had a staff of maybe 6 to start out with. Members of the task force were appointed, and I was named chair. We had $7.2 million to distribute to counties, but we had no system or structure to do that. We had no way to award funds to the counties. We had no way to collect county plans. We had nothing except the money and direction from the bill about what we had to accomplish. So we needed a way to monitor the county's plans and data, to decide how the money should be distributed, and a way to actually get the money to the counties. So Jim and I went to talk to Dr. Tony Fabello, who was then the director of the state's Criminal Justice Policy Council. And he advised us about how to survive the first year and how to begin to build a framework from scratch, from nothing, to oversee and fund indigent defense in Texas. He said the first thing we needed was a short-term plan, one that was not too ambitious for the first year or so, because if we tried to do too much, we would fail. Back then, there were still plenty of people who thought counties should do indigent defense on their own without being told what to do by the state. And the existence of the task force beyond the first couple of years was in no way guaranteed. I wondered myself whether it could succeed, but it was my baby now, and I was going to do my best to see that we did. There was a lot of contentiousness back then, and Jim Bethke bore the burden of assuring counties that we wanted to help them, not order them around. And that's been one of the hallmarks of TIDC ever since. And eventually counties began to understand that we really meant it. We believe that people in the local justice system know better than we at the state level about what's going on in their county. We depend on them to tell us what they need help with and for ideas about solutions to their problems. And they depend on us not just for money, but for ideas and advice and help. And we always try to remember that overburdening counties is not the way to achieve success. People can come up with amazing things if they have the freedom to do so and the funds and some help in carrying out their ideas. So many of our successful programs have started with ideas from local authorities. Over the years, this collaboration between local authorities and the state has produced one of the best indigent defense systems in the country. With the indispensable help of Texas A&M's Public Policy Research Institute and Dr. Dottie Carmichael, we collect data from all 254 counties, including appointment of counsel rates, spending, and per capita expenditures per county. We do both fiscal and policy monitoring. We've gone from $7.2 million in funding for the first year to $47 million in state funding per year. And this year, because of Operation Lone Star funding and ARPA funds, $93 million, which is more than the total that was spent on indigent defense by all the counties in the year before SB 7 took effect. 20 years ago, only 7 counties had public defender offices. Now there are over 60. We have managed assigned counsel offices. That was a new idea in 6 counties. We have a regional public defender for capital cases. That was a new idea too, one that came from local authorities that handles death penalty cases in 185 counties. We have issued numerous publications and research papers. And this year, for the first time, TIDC and OCA have begun collecting data on child protective services cases using the framework that we began to build 20 years ago for indigent defense. And we have a website that should be a model for any other state agency. I want to acknowledge our director, Jeff Burkhart, for his dedication, but most of all for his creativity. Like Jim Bethke, Jeff never rests on his laurels. He is never so focused on the incredible day-to-day burdens and demands of his job that he forgets to sit back and look at the big picture and come up with new ideas and ways to improve our indigent defense system. And with Jim and Jeff both, staff, and our commission members, I think that is the true hallmark of this organization. Thank you for being with us and enjoy the program.
Kathleen, you're muted again.
I'm just modeling for our future panelists later today how I'm not actually a Zoom guru, more like a Zoom get through it. But Judge Keller and Commissioner Ellis, I want to say thank you so much. I'll be taking us through the next portion, so I'll be making you attendees again, but Commissioner Ellis, I'll be bringing you back up. Zoom is so strange, isn't it? It's not like real life at all.
Just hope I don't have to touch a button. We're in trouble if I have to touch something.
No, you will be magically transported back to the other room. So thank you very much. And feel free to turn your camera off as I take care of that. And we'll be moving on to the next section of our event, which is the getting to know our audience. And this is where I'm asking for kind of your help in doing something that's really new and exciting. We're actually going to try and make this interactive. So as Andrea said at the beginning of the presentation, if you are a social media person, if that is your thing, great. Let's use hashtag FDA at 20 to spread the word about the Fair Defense Act. We have 140 people with us today, but there's so much more that people need to know and learn about Texas and what we're doing here. The next thing we're going to share that I'm really excited about to see if it works is a software called Poll Everywhere. And we have this opportunity thanks to Professor Marsh and the University of Texas. It's a way for you to actually interact with our program, answer some questions that will appear live on screen. So this is the instructions part. There's 3 ways that you can participate. One is on your computer, which is what I would suggest you do if you can. Open up your internet browser, which might require you to minimize your Zoom screen a little bit or take it out of full screen mode, and go to the website http://pollev.com/FDA20. And Olivia Lee and Bill have dropped that link right in the chat. You can click that and it will open up the window. But not everyone's able to participate on their computer today. So you can actually participate on your phone by texting FDA20 to 22333. Now, for folks playing along with your phone, you won't be able to do every activity, and I'll let you know if it's a phone activity or if it's just computer. But if anyone's ever voted for Dancing with the Stars, I actually really like Dancing with the Stars. You've done this before then. And then for people who understand QR codes, which I admit is a little bit beyond me, you can scan that QR code on iPhones by opening up your camera app. I think with Android, they have other ways to go about doing that. And that will open up a browser on your phone to play. When you open up that internet browser, you'll be asked to put in a screen name. You may have to accept cookies, but I want to be very clear that all answers are anonymous and will not be recorded. And when you get a screen that looks like what you see here that says waiting for FDA's presentation to begin, then you know you're in the right place. And in case you have any issues at all, we have some folks on staff that are ready and willing to answer your questions. So if you have any trouble along this process, just put that in the chat and we'll have folks helping you. And again, make sure that when you play, you're choosing your answers on your internet screen, not on the Zoom window. So you're going to have both screens open at the same time. And know that you only have to do this at the beginning of our day. We'll use it throughout actually the presentations. So once you get it set up, just kind of put it in the background. Some of our presentations will not use this software, so just kind of keep it up in the background and then we'll let you know when to play. And once again, remember, have your Zoom window and your internet browser up. Again, that might be Chrome, Safari, Firefox, whatever you use, it should work. Okay, so now we're going to get to our first activity, and let's see if this works. And I did see in the chat, the social media hashtag is hashtag FDA@20. All righty, so here we go with our first event. Where are you watching from today? So hopefully some of you were able to open it up, and what you hopefully are able to see here is the map populating with folks. And it will be really neat to see of the 164 people we have on now, where people are watching from. And as we do these kind of practice questions, I'll give everybody about, I would say 30 seconds or so to go ahead and enter their location. And if you're not from Texas, that's okay. We won't hold that against you. As some folks have done, just go ahead and put your answer in that little box there. And again, make sure you're clicking on the internet screen, not on the Zoom screen. But we can definitely see it already filling up. We have folks all across the state, but a lot of folks in Dallas, Austin, San Antonio, and Houston, but also folks in other parts of the state as well, and even up in Arkansas, which is really cool. All right. Go ahead and let those answers come in a little bit longer. Excellent. That's really great. Well, I'm really glad with my instructions, some of y'all were able to follow them. So that's exciting. We're going to go to the next question now to practice, which is, should you put beans in your chili? Hot topic. And as you can see, this will, for those playing on your computer, you'll hit the button. But for those of you playing on your phone, once you text to 22333, you text either A or B, depending on if you're right or wrong about whether beans should be in your chili. And what's really neat when we get to the trivia section of our event, again, you'll be able to guess and you'll be able to see what other people vote on. If you have additional thoughts or comments about this question in particular, please feel free to use the chat. I can already see this has engendered some really intense feelings among our folks. But as it stands right now, it looks like we have the, it looks like the majority of folks say it's okay to put beans in your chili. And all right, so the last practice question we have today, and in an attempt to better get to know you, tell us what you do for a living. What role best describes you? And again, I'll give folks just maybe 30 seconds or so because there's quite a few answers. But I thought this might be a neat way to see who's in the audience. And what's really neat is it looks like we have folks from almost every category here today. So that's really exciting. And again, this is really cool to try to just kind of get a better idea of who's here. You always wonder with webinars, who's watching. And so, yeah, thank you so much for getting ready with Poll Everywhere. Thank you for playing along. Like I said, there'll be more opportunities to participate, and we hope to really make it dynamic. So I think with that, we are ready to head to our panel, which is the past. And so, Andrea, I'll go ahead and bring our panelists up and hand it over to you.
Hello again. While I am waiting for my fellow panelists to appear, I will briefly introduce this session. Our first session this morning is structured as a conversation about the Fair Defense Act and its early implementation among some of us who were working in this area back in 2001 and in the early days of the FDA. So joining us again is Commissioner Ellis, the Senator author of the FDA, Jim Bethke, the first director of the Texas Task Force on Indigent Defense, which later was renamed the Texas Indigent Defense Commission, Janie Myessie, a defense attorney who was a solo practitioner when the FDA was passed and who now works at the Harris County Public Defender's Office, and myself. I was involved in advocacy around the FDA's implementation in my former role as the founding executive director of the Texas Fair Defense Project. Each of this morning's speakers represents a different role in the FDA universe, and the idea is that we will ask each other questions about our experience in the early days of the FDA after I kick things off with an opening question to everyone. So I'm going to start by posing this question to Commissioner Ellis, who I will, because of how I know him, call Senator Ellis at times. I can't help it. But I will ask everybody else to sort of add to his answer, and we're kind of going to build on it together. Those of us participating in this discussion were involved in public defense in Texas when the Fair Defense Act was passed, or we became involved immediately after its passage in direct response to the bill. But many people in the audience weren't working in this area 20 years ago, and although they may be very involved with public defense now, they may not be as familiar with the ins and outs of the Fair Defense Act itself and its early implementation. How would you describe to them what the FDA is and what it does?
I'd say, first of all, it forced every county to at least have a discussion about what they were doing. Data was important because all of a sudden you could look at, it was a lot more transparent, which could generate some embarrassment. And then we passed a broad framework over to Jim Bethke, figure out, and Judge Keller, what to do with it. So it was a broad framework, and it forced a discussion all throughout the county. But I'd say in the early phases, if you go back and look at the bill, it was broad guidelines. Caseload standards were there, but a very broad framework.
All right, so Jim, how would you add on to that, or how would you describe the bill, and to what extent, what would you add to that?
Good morning, Andrea, and again, thank you for inviting me to participate. It is great to see Commissioner Ellis, Janie, and Judge Keller, and all the other folks that have joined on. But in reference really to what the Fair Defense Act is, I want to start first with, I'm grateful that Governor Bush vetoed the bill in 1999, because the deficiency of that bill is it provided no funding. So when Senator Ellis back then was able to get the Fair Defense Act passed in 2001, what was absolutely critical was funding, because it was the first time that the state of Texas provided funding for indigent defense services. Without that funding, there's no way the commission, the staff would have been able to really move the needle the way that we have. And so funding is critical. As Commissioner Ellis and Judge Keller have said, the reporting requirements, and Judge Keller mentioned this, the plans from all 254 counties were due on November 1 of 2001 before the governor even appointed the task force, and OCA stepped up to the plate and gathered that. And Bob Dawson, who's Pat's mentor and friend and champion of this, he provided his three law students. So really the funding, the local reporting, as Commissioner Ellis said, it really forced conversations in each of our 254 counties. And then critically, you have a state entity that was created with staff to work with all of the local jurisdictions. So that's what I would add on to that, Andrea.
Jim and Andre, I should throw in, and it's in my notes, the FDA did create statewide minimum standards for indigent defense, including timely appointment of counsel, method of counsel appointment, and requirements that attorneys have access to investigators, which many didn't, and are compensated for their time both in and out of court. And of course, that task force But at least we did have that. The FDA created those statewide minimum standards.
Mm-hmm. All right, so Janie, I'm going to bring you in now. What would you add to sort of help people kind of understand the context of the FDA?
You know, I was speaking with you about it yesterday, and as a practitioner, I had no idea this was going on. I mean, I had worked at the Court of Criminal Appeals for Judge Charlie Baird. I left in 1999, and I came out and hung out my shingle in Houston, and I found it very difficult. I didn't know that things, I only knew that that's how it was. And I learned very quickly that I would not make it as a solo practitioner in Harris County because I didn't have the friends of judges. I wasn't a former DA. Didn't matter that you worked at the court. It was all about bring kolaches for breakfast, and then you might be appointed. And I really sat back last night and I thought of how many times I would sit in a jury box and hope a judge would pick me. And I'd always go to the 182nd first because docket was at 8 a.m. If he didn't pick me, I could run to another court, see if I would get picked. So all of this is just like miraculous to me, but I didn't know any of it was occurring.
I won't talk about the campaign contributions. Hey, I'd be the one being a politician myself to say, with those kolaches, what some of them didn't tell you was they were also on the fundraising committee.
So Janie's kind of contribution kind of opens the door to what I want to add to this. I know I was going to go last, so I kind of didn't address the structure. To me, like the FDA is this bill premised on the idea that we can improve the quality of representation that people accused of criminal offenses receive by setting up governmental structures and incentives around county officials and judges in what was conceived as their role as the entities responsible for fulfilling the guarantee of the Sixth Amendment. But the bill says very little about clients. It actually doesn't really say that much about defense lawyers. It focuses almost all of its attention on county commissioners, judges, and magistrates. And so now we're going to move to the part where we get to kind of throw questions at each other. So I'm going to start by throwing one to Commissioner Ellis, and then he gets to go next and pick on somebody. Why was that focus of the bill on counties as the target? I mean, I've thought about this for, you know, I've been working in this area for a long time. Was it a matter of political necessity that that's what could get through the ledge? Was it practicality? That's who the ledge could give money to and had like the ability to act upon? Or was it really thinking that that's where the buck stops? This is a government provide qualified defense lawyers to people, so we're going to focus on the government to fulfill that.
It was a reaction to the reality of what was occurring. The state of Texas never funded indigent defense. That was a responsibility, although it is a constitutional responsibility. The state just abdicated it to the counties. I'm guessing by design. With 254 counties, only one state, as I recall, in the country has more counties than Texas. Is not a big state. It's Georgia, if my memory serves me correct. Remember, the bill was vetoed in 1999. I will tell you this, the county officials, just like you, Janie, they didn't quite know the bill was moving either. You know, the old saying when I used to intern for Governor Bill Hobby was there are two ways to pass a bill. One is when everybody knows what you're doing. The other one is when nobody knows what you're doing. And I was always a prolific bill filer. If you measured my success by the percentage of bills I passed compared to how many I put in, I was an abysmal failure. The fact I was finance chair helped quite a bit with that bill and all the others. But so in my mind, I figured after the bill was vetoed by a governor who became president, after the bill passed, maybe one person voted no in the House, one or two, but I think in the Senate it passed unanimously because I took the real meat out of it. Initial bill that was filed, if you go back to that old Texas Observer article, but I was passing what I could pass. And at the last minute, I should mention Chairman Hinojosa, Representative Hinojosa, who's in the Senate now, was the House sponsor. And he was the right one to get it through. When we got it out of the Senate with lightning speed, probably because I had the finance pen in my hand. In the House, I had to go over there and help And some people who I thought would have been for it gave me problems, but a lot of people made money off of that old system. I wanted the data collection more than anything, because if you could collect the data, you could make the case. And I think, Jim, your perspective, all of you on the outside, I don't know if you knew this thing was moving. And once it got there, by the way, a whole lot of stuff came out of that data collection, by the way. That's why that was so important. 8 years later, 2009, we passed the bill to create the Office of Capital and Forensic Writs to defend indigent people. And we expanded the handle on junk science cases, through the Forensic Science Commission. So that data and having all of these advocates, but we couldn't put everybody, this is not a bill where you could put everybody at the table and get it passed. It wouldn't have passed. And just thank God for Bill Ratliff and the luck of giving me that finance pen, because people didn't mess with my bills quite as much.
All right, so who do you want to throw a question to now, Commissioner Ellis?
I'm gonna throw it to Jim. Jim, I'd like to get a sense of if you could do it over again, just some sense of things you would change in the bill, and comment a little bit about stuff you managed to get changed along the way. Now that you out, you can probably admit sometimes I would ask you what's going on around the country, and you tell me, and all of you couldn't touch it. I get kind of creative on certain things, but walk through what you do differently, and just some sense of how you got other things changed along the way to make a difference.
Well, Commissioner, if I could wave a magic wand, and again, you being Chair of Senate Finance and getting some funding was critical, but kind of looking at where we're at, and tremendous progress has been made, but we're still falling short in a good number of jurisdictions. The challenges jurisdictions than those that we have in our urban counties, in Harris and Travis and Bear and others. But funding, Texas in 2001, I think, was one of 6 or 7 states that provided no funding. And funding is, as you mentioned, you found money that was, getting swept and just used for other purposes. But that funding is out of the general revenue or GRD. I forget the term now. They've been away from the state for 4 years, but it's basically from fees, and the state really needs to provide general funding. I think, and Jeff will have these stats and the team at TIDC, but I think over 50% or 2/3 of the states fully fund indigent defense. At the end of the day, local jurisdictions need the funding. So funding was absolutely critical to enable our task force, now commission, to accomplish what it has accomplished, which is really quite remarkable. But what we did is we leveraged county spending. Counties are getting money, but they're spending significantly more than they did before. And I'm one of those that I really do feel this is a state responsibility to meaningfully fund it. I think the most significant program that the task force and the board directed staff to do was we have both the regular, Andrea, what's the regular funding? Formula funding. So we have the formula funding, which keeps kind of the grease on the gears and all of that. And that was critical, because that was a tool in order to get every jurisdiction to report. But what's been transformative is the way the Task Force Now Commission uses its discretionary grants. And because those funds would encourage a jurisdiction to change the way in which it provided its defense services to the poor. And then there was actually additional requirements. And that's what I feel is one of the most significant things that the task force did, and that was probably in year 2. Year 1, it was just to get the money out to the counties to get them to really do the reporting. And one of the things you mentioned, Commissioner, and this is something where we received probably the most challenges we had was the timing of assignment of counsel. In the urban jurisdictions, it had to happen within 1 day, and then the rural jurisdictions within 3 days. And how do you measure that? Because if you're not able to measure it, how do you know it's even being done? So the task force now has a team that, you know, goes out to see how well local jurisdictions are meeting those requirements. So mine is funding. I would kind of, Janie, you know, go work for the Court of Criminal Appeals, which I think I was at the Office of Court Administration. You went into private practice, and now Janie, you are chairing the legal service support in criminal matters for the State Bar of Texas. What have you seen that, you know, is good that's been done? And then what do we need to do to, because we definitely still have a long ways to go in making this the best that it can be. What are your thoughts on what's the good, and then what do we actually need to do in order to really get to the level of where we'd like to be?
Oh, one thing I'd like to say is thank you, Commissioner Ellis, for explaining about how the funding came to be and how these fees and court costs have funded indigent defense. I didn't know that. And hearing you say that you would have done that differently, because I have literally spent a decade fighting these court costs and fees from our clients, and I never understood the genesis of it. So thank you. And that's one thing with our committee, we worry a lot about how these fees and costs affect our indigent clients. For so long, people would always say, oh, well, they never collect them. You know, people go to TDC and we don't collect those. Yes, they do. It punishes clients continuously while in prison. And when they get out, they get a letter from the clerk, come on down. And I would thank Senator Zaffarini in 2017 and the last session has really given, for the first time, the opportunity for district courts to weigh, and county courts, any court, to weigh court costs before you just had, I mean, OCA had a cost collection like whole program, and they don't have that anymore. So I think there has been progress. I think there needs to be more progress that indigent defendants don't get a court cost that says you have to pay for indigent defense. That just doesn't make any sense. And also a huge area is forcing indigent clients to repay their attorney's fees. That is happening. Our committee has been looking at it, and we have seen counties where they make the defendants pay more than what the attorney was paid. And so that's sort of where we're going as a committee, where I'm fortunate to go as a public defender. I could never fight these battles if I was in private practice. Let me tell you, no court would pay me to fight for $14 court costs. They'd be like, Myessie, we're not paying that. But I'm a PD. And I told Alex when I began this, I said, hey, I want to attack the court costs that fund our office. And he's like, okay, let's do it. And we have had some success. Even when we have success, TIDC comes and takes that money and puts it back into their coffers, not back in our client's pocket. So that's sort of where we are and where we're going, and our committee is working very hard on that. So my question is to Andrea. What was your, I mean, I always look at you as starting this, and I think what was your idealized vision, what you thought you really wanted, and how close we are now to that?
Well, first, before I dive into that question, I just want to note that Janie is also on the State Bar Committee for the provision of legal services of criminal matters. When she talks about our committee, that's what she talks about. She is our chair and leader. This was my first job out of law school, so I do not want to pretend that I had some vision when I was writing a fellowship application about where I wanted public defense to go in Texas. And for all of my, critiques of the bill, which have actually changed over time, right? Like how I feel about different parts of it, it absolutely gave us something to work with. Like where there was not anything to work with before. There was no data, there was no structure, there was no reason that any county official in the state of Texas would have talked to somebody, wouldn't have talked to Jim even, let alone somebody like me who is coming from like an outside organization. There were times where I was like very pessimistic because we would hit these walls where it was just like, okay, I'm having lots of meetings with counties, but we can't agree that people need lawyers before they're indicted. And we would get kind of stuck for a while, and then we'd have to go try something else, like in the courts. It was really, my ultimate vision is to have like a public defender system that makes sense in this state. And for a while that seemed very far off, because it was really slow starting after the Fair Defense Act to see public defender offices get going. But it really was as that discretionary grant program that Jim mentioned expanded, that we have really started to see that shift more, and it's still shifting. Even in the last couple of years, we just got a public defender office here in Austin. So we're getting there, but I mean, it's a vision that has like evolved over time to plan figure out how to do public defense work in a state that didn't have a public defender system at the time. And so we are kind of at the end of our session. So I would love to just give everybody else a chance to weigh in on this idea. We're about to talk about the present after our break and hear about some of the programs that people are working in now. Is this kind of the future that you all imagined when we were working on the FDA and working on getting it implemented at the beginning? Commissioner Ellis, you're muted. I think you're talking, but you're muted.
I noticed Scott Ellis in the chat box made note that there have been significant changes along the way, and there have been. So check out his chat changes that Representative Gallego and I made. But look, here's the biggest change, the dynamic to change. The way it worked in Texas prior to 2001, this bill being passed, the only way you could create a public defender's office will be if a county went to the legislature and asked for it. And very few counties did. And nobody discussed it, by the way. So one of the biggest pluses of this bill was, under this bill, every county in Texas could create a public defender's office. Now, to keep the bill from getting vetoed, I did have to put in language that said you had to go get a majority of the judges who voted in secret, by the way. You could probably force it. It doesn't address it, but you could force that. But look, we created an atmosphere where you go away from this attitude of thinking it's okay for a judge hearing somebody's case to pick the lawyer for the person accused of a crime. Now, by the way, I joke with the bar from time to time. It violates the ABA principles. If they really had some chutzpah, it would violate the rules. Now, you practice law without a license. That violates not just the principle, it violates the rules. But we changed, and the whole attitude that some people had, and some still have, from a few questions I see in the chat box, as though it's okay for a judge hearing a case to pick a lawyer. Who on this, not just this panel, but in watching this Zoom, would let your child go to court if they were accused of a crime and let the judge pick their lawyer? So we moved away from that. Now people, they start getting fidgety when you have to explain it. The sleeping lawyer cases, all of that. I will say in defense of the way we funded it, I used to call him, Senator Gregory Luna was the master of fighting all those fees. God bless his soul, he died some years ago out of Bear County. But this was a fee. These were fees that were being collected and never used. They were just put in the lockbox, so to speak, as a method of finance to balance the budget. But I'm not sure I would have had the clout if I'd said, let's go put 50 million, 70 million in indigent defense, but you have to start somewhere. But I think more than anything else, this bill has changed that dynamic. Even among my friends in the defense bar, where it was okay to go make a good living off of these court-appointed cases and then have your private practice. In fact, years later, because of the FDA, we passed a bill, Bethke, I had it in the Senate, I think I did, I don't know who had it in the House, well, you have to show what percentage of your practice these appointments are. And you know, I would have made that a little clearer. I would have defined percentage. Best way I define it would be how much, if you make $200,000 a year and 150 from court appointments, that's the percentage of your practice. But it's made a tremendous difference, but there's a lot more work to do. And it means advocates like, well, Andre, you still an advocate, all of you in academia, you got to go county to county and fight it. And you got to have somebody on the state level. Look, I pushed Harris County to do it, and I was then roll forward. Now I'm sitting here. And on the day of George Floyd's funeral, we made a commitment, passed a resolution. We'd get that office up to 50% of the cases in 2 years. When I got here as a county commissioner, it was handling 6% of the cases. Here we are 11 years later. It might be 20 some odd, maybe 30%. But you still have to fight. This is Texas, and there's not a lot of sympathy on these issues. Although we say people are innocent until proven guilty, most people don't really operate that way. Create more PD offices. And Jim, what's the number we have now compared to where we were in 01?
Oh, that's a trivia question. We'll get to that momentarily after the break. So like we're towards the end of our time, but Jim, do you have something to briefly kind of add to this? Is this what is the present where you thought we were going to be 20 years later?
I'm delighted, you know, the progress that has been made. And as everyone has said, you know, there's more that needs to be done. I think, and I want to, you know, we've got probably 25% of our audience, private attorneys that are taking court appointments. I want to say thank you to each and every one of them that are providing these services, because it really, the services that they're providing, when they're providing the level of representation that's required, they're getting paid probably anywhere from 15 to 25% of what they would be making in private practice. Again, my mantra is on the funding, and whatever we can do to increase that. But and then Andrea, thank you for everything that you've done from the inception. I know we're out of time, but what was absolutely wonderful, I could wear my white hat into the counties, and then you would be there with me, and you were you were just out of law school. They were able to talk with the judges or the commissioners or whomever it was. I said, hey, help me help you not get sued. I said, she's a good woman, but she will sue you. And congratulations, you know, on your representation of Mr. Rothgary, winning your very first lawsuit that you filed before the United States Supreme Court, 8-1. So thank you, and Commissioner Ellis, Senator Ellis, and Janie, and everybody else. So I'm grateful to have had the opportunity to be involved with all of you and everybody who's on the line, and this, you know, the whole team in Austin.
Thank you. We have all been working together a long time now. So Janie, do you want to have a final go at that question?
Well, I would just say that, like, this job as a public defender is what I always imagined in law school, but it didn't exist. And my friends were shocked when at 47 years old, I said, I'm closing my practice and going to work as a public defender. They said, aren't you doing it the backwards way? And I said, I don't know, but this was my dream. So I'm grateful to all of you for all your hard work, because it has made a tremendous difference in my life and so many others.
All right, well, thank you. I want to thank all of our speakers, and we are about to take a 10-minute break. We're running 4 minutes late, so I'm going to take the prerogative to say everybody come back at 10:14 for the next round of Kathleen's game. We have some great trivia questions where you will find out the answer to the question that Commissioner Ellis posed about how many PD offices we have right now. But go grab coffee and we will see you back here in 10 minutes. Thanks, everyone. Hello, sorry. I just got a message from Kathleen. I was waiting, she was waiting for me, I was waiting for her. We are ready to get started and do our public defense trivia.
All right, thank you. Okay, everybody. How well do you know public defense in Texas? This is going to be a trivia game, and I am your host. So just to remember, you know, we practiced earlier in the morning with having that web browser screen where we will answer our questions, or we're using our cell phone to play along. So hopefully you still have that up. Bill or Olivia, if you could drop the link in the chat just one more time in case people closed it. Go to pollev.com/FDA20 or text FDA20 to 22333 to join. And you'll be putting your answers in the web browser screen or texting them on your phone. And as we said earlier, there's no grading. These answers aren't being recorded. So just use them for bragging rights among your friends and family. I made my husband take this quiz last night and he did really well, and he's a chef. So hopefully that means, I guess, some of what I do is rubbing off on him. So let's get started. What year was the United States Supreme Court case Gideon versus Wainwright decided? So what I'm going to do is allow you to see the answers as they come in, because this isn't a graded exam and nobody's going to get a score. So I think it's kind of fun to see what people are answering. And I'm going to give everyone 30 to 40 seconds in case you want to think about it. You can change your answer on the web. And for folks who can't play along, feel free to use the chat as well. You know, if you aren't able to play along those other ways. So just about another 20 seconds, and then we'll reveal the answer. All right, well, the majority of folks were correct. It was 1963. All right, next question. How many state constitutions guarantee the right to counsel? And again, I'll give you about 30 seconds to respond. And actually, this time I'll hide the results until that way we can have an even playing field. But you can see here in the corner that we have about 50 people that have already responded. So I really love the energy going right in. There's a lot of different theories on how to answer multiple choice questions. Unfortunately, I don't know any of them. All right, so let's see what everyone said first. We have, a number of different answers here. So about 30% of folks said 50%, 24 said 49, then 29% of people said 25 states, and then some people said, hey, this is a trick question. And the answer is 49 of our United States state constitutions guarantee the right to counsel. So who doesn't? Virginia. I'll just leave that one alone. Next question, which section of the Texas state constitution, now that we know that Texas's constitution does guarantee the right to counsel, what is the specific article and section number? And again, I'll give you about 30 to 40 seconds to answer this one. All right, closing the poll in 10 seconds. So if you're kind of wavering between, go ahead and make a guess. 5 seconds here. 3, 2, 1. Here's where we're at. All right, so 68% of folks said it's Article 1, Section 10. And you folks would be correct. That is the provision of the Texas State Constitution that guarantees the right to counsel. That was a tough one. That was a tough one. All right. So not counting the regional public defender for capital cases, approximately how many Texas counties out of 254, which is how many counties we have public defender offices or managed assigned counsel programs? So this is answering the question that Commissioner Ellis asked us in the past panel that then Andrea said, hey, wait, we have a trivia question on that. That's this one. So again, out of 254 counties, which are helpfully pictured here if you needed a visual reference, how many of them have public defender offices or managed assigned counsel programs? And again, I'll give folks about 30 or 40 seconds to think it over. It's not graded, so you don't have to think too deeply. Just go with, you know, an answer. Twenty more seconds. All right, 5, 4, 3, 2, 1. Let's see where we're at. 60 people said, or excuse me, not 60 people, 48% of people said 60. Nobody said 274, which is great because that's more counties, that's more than there are counties. So everyone gets a gold star from me today. And that 48% of folks, that is correct. There are now 60 counties that have some sort of managed program or public defender office. Okay, and if you wondered where in the state these managed programs are, here's a map that we use. You can see that the salmon color here are the regional offices, blue are the managed assigned counsel systems, orange are single county public defender offices, and green are counties that have both a PDO and a MAC. All right, so now one for the history buffs in our audience. The first public defender office in Texas was founded in what year? 30 to 40 seconds on the clock. All right, you guys are getting good at this. The answers are coming in quick, which is great. I'm going to give folks another 20 seconds or so. Think it over. Ten seconds. All right, let's see where we're at. All right, so a lot of folks said, majority of folks said 1970, with the rest of the folks split. The answer is, whoa, 1914, believe it or not. 1914 was the first year that the Public Defender Office was founded in Texas. And where, might you ask, was that home of that first Public Defender Office? Well, there were two separate counties in that year, 1914, that established public defender offices. So what were those two counties? And again, 30 seconds on the clock. All right, 5 seconds. See what folks said. The majority of folks said Dallas and Travis County were the first places to open a PDO. And believe it or not, it was Harris and Bell counties that were the first counties to open public defender offices in 1914. So congratulations to the quarter of folks that got that right. All right, now this is a little bit of a different question, and I know we're running a little behind, but the rest of these should be pretty quick. This involves ranking for 5 of our counties in order of which one spends the most on indigent defense per capita to which one spends the least. So this is one for our folks who are playing along on the computer only. Click on the county and then go ahead and use the little arrow buttons. You have to click on them. You can't drag and drop, unfortunately. But go ahead and rank from who spends the most to who spends the least per capita. And again, I'll give us about 30 seconds. This one's a little less intuitive in terms of having to use the buttons. But again, you know, whatever they said back on whose line is it anyways, the answers are not made up, but the points don't matter. So do your best, and then I'll reveal all here in about 20 seconds. All right, 10 more seconds to get your answers in. All right, let's see what folks said. All right, so most folks thought that if we're ranking the counties in order of who spends the most to who spends the least of these particular counties, we thought it was Harris, El Paso, Travis, Dallas, and Bexar. Well, the correct listing, El Paso was the highest at $16.04 per capita, followed by Harris, Dallas, Travis, and Bexar. All right, next up, pretty straightforward multiple choice question. In fiscal year 2020, how many counties out of 254 reported $0 in investigative expenditures to the Texas Indigent Defense Commission? And this time there's no answer that's over 254. Tried to make this one a little harder. And again, we'll give you 30 seconds on the clock. All right, looks like all our results are in, so let's see where we're at. All right, so we're almost kind of split between 40, you know, about a little less than half of folks said 70, and a little less than half kind of doubled that, double or nothing, and went for 140. And the answer is 140 counties reported $0 in investigative expenditures to the Texas Indigent Defense Commission. 2 more questions to go. Another multiple choice, so both our people playing on our phones and our computers can play. In 2020, what percentage of defendants, so this is by defendant, were represented by attorneys with caseloads above the TIDC Texas guidelines? And again, 30 seconds on the clock. All right. 30 seconds have passed. And folks, again, are kind of split between 40% or 60%. The answer is 40% of defendants were represented by attorneys with caseloads above the Texas guidelines. All right, so last question, and again, this is only for our people playing on the computer, but click on the map, click on the arrow. Do you think indigent defense appointment rates increased or decreased in fiscal year 2020? So just drop a pin, kind of like you did with our very first activity, and then we will see what the answer was in 30 seconds. And I really appreciate the person who went for the middle, because that's what I would do. And so we have at least one vote who says it didn't change at all. I didn't put something on here for that, but I should have. So whoever that is, you are my favorite. All right, 5 seconds. And the answer is appointment rates increased in fiscal year 2020. So that's all, folks, in terms of our interactive trivia. I hope that you learned something. I hope that you had fun participating. It was neat to see what everybody thought. And again, thanks again for trying something new. This is new for us, but we really wanted to make sure that you were a part of this. We've got 180 people online with us today, so it was really fun to have a way for us all to kind of interact and play together. All right, now I'm going to hand this over to Jeff Burkhart.
Thanks, Kathleen. So we've heard a lot about the past, and I want to thank again Commissioner Rodney Ellis and Jim Bethke and Andrea Marsh, Janie Maselli, Judge Keller, who spoke about the past. A lot of those folks are friends and mentors to me, and so I really appreciate all the work you've done over the years. We wouldn't be where we're at today with everything you've done. So where are we today? That's what we're talking about next. We're going to talk about the present. What is the current state of public defense in Texas? We thought we'd try something a little bit different today. So I'm going to give a brief overview. And then we've got 11 speakers. And the reason we did this, there was so much going on in Texas public defense. And we're going to have each of them give you just about a 5-minute presentation on their area. We're going to hear about urban public defense, rural public defense, managed assigned counsel systems, the county perspective on funding. Let's see, public defense oversight, caseloads, mentoring, counsel at first appearance. That's a big issue, by the way, in Texas. Padilla, the use of peer specialists, and finally, community engagement. So you're going to get just kind of this kind of neat overview of all these different areas, very brief. And what I would encourage you to do is after you've heard from each of these speakers, and just they're going to give you these high level, very short, about 5-minute kind of overviews of their area. Don't hesitate to reach out to them after this presentation today. And if you want to get more involved in whatever that is, caseloads or peer review or whatever, or peer specialists, whatever it may be, please reach out to them. A couple notes before we jump in. First, some of our speakers will have PowerPoints, some of them will not. We're going to have a pretty good mix. But when you see the PowerPoint slide up, you should see the PowerPoint on the one hand and the speaker in another box. One little tip, if you roll your cursor over between those two, there's a little slider bar, and you can actually slide that back and forth to make the speaker bigger or smaller, or the PowerPoint slide bigger or smaller. So feel free to play around with that a little bit. I think that's it. Thank you, Kathleen, for the great trivia questions. I have to confess, even as the executive director of the Texas Indigent Defense Commission, I got 1 or 2 wrong. So those were really good questions. So let me go ahead and pull up this PowerPoint.
And Jeff, we have everyone from the panel is here.
Oh, great. Good deal. Welcome, panelists. And Kathleen, can I just confirm, are you seeing do I have the right view on there? Or do I need to swap the presenter view?
Go ahead and swap the view real quick.
All right, are we good?
Perfect.
All right. Well, thank you, Kathleen. So again, my name is Jeff Burkhart. I'm the Executive Director of the Texas Indigent Defense Commission, and we're here to talk about the present. Welcome to the present. First, I want to talk to you about spending. How much do we actually spend on public defense in the state of Texas? Before the Fair Defense Act, the state spent basically $0 on public defense. There were some exceptions there. There was a little bit of money that, as Judge Keller mentioned, that was spent on habeas, but really there was no significant state investment. Today, and I want you all to use the chat if you can, what do you think the state spends on public defense every year? What does the state of Texas spend on public defense every year? Go ahead and just drop this in the chat. Just give me a number. Is it $2? Is it $100 million? Is it $1 million? 500,000? How much do we spend? Let me give you just a few seconds. So you have some guesses, $34 million. Other guesses on how much the state spends? Tricky question, right? The answer is $47 million a year now. So we made some progress, right? We've gone from $0 of state spending on public defense, or close to that, to about $47 million. So that's a pretty good leap. But let's put that in context. Before the Fair Defense Act, 100% was on the shoulders of the county. The state spent, or really covered a 0% of the funding. What percentage do we cover now? The state covers about 13%. So again, we've made some progress, but we have a lot of room to improve there. The vast majority of the costs for public defense in the state of Texas are still shouldered by the counties. This is how much we spend collectively between state and county for public defense across the state. So in any given year, we're spending about $300 million on public defense. That number actually dropped a little bit during COVID, but we think it's going to bump back up. Now, this is something really interesting. I think this is a really important marker if you're trying to figure out how much do we spend and is it the right amount. This is per capita expenditures, per capita spending for public defense nationally. This is the average. What is per capita spending? All you're doing is taking the population of an area, a county or a state. You take that number and you look at how much they spend on public defense and you divide one by the other. So it's a real quick and dirty kind of measurement. $17 per capita is what we spend on average across the United States. How much do you think Texas spends per capita on public defense? Drop some guesses in the chat. Do we spend $5 per capita? Do we spend 25? Are we higher or lower than that national average? What's your guess on per capita expenditure? I see one guess, $10. $5 per capita. These are good guesses. $7, $5, $9, $1. Whoa, man. $13. These are really good guesses. The answer is we spend about $10 per capita on public defense in the state of Texas. So again, the average nationally is $17 per capita. We spend about $10 per capita. So here in Texas, we spend roughly 60% of what most of the nation spends per capita on public defense. We're on the low side. One of the big issues we see, though, is that some of our poorest counties spend as little as $1 per capita. So way, way less than the rest of Texas, way, way less than most of the nation. Let's talk briefly about systems. How many public defender offices did we have, or how many counties had public defender offices before the Fair Defense Act? Depends on how you count it. But roughly we had 5, 6, or 7, depending on how you count the numbers. How many counties do we have now? You might remember from the trivia before, we have roughly 60 counties that have a public defender office in Texas. So again, depends on how you count it, but roughly 60 counties. The neat thing, though, is that we have 22 counties that have been added to public defender offices just in the past 2 years. So in the past 2 years, we've added 22 Texas counties to public defender offices. So we're actually increasing the rate at which we're building public defender offices, which is, I think, generally a good thing. Before the Fair Defense Act, we had 0 counties with managed assigned counsel systems. And this is one of the big innovations by my predecessor, Jim Bethke. This is an idea that had been used in Massachusetts and California. It's being used now in Colorado, and New York, and Michigan. We now have 6 counties in Texas that have managed assigned counsel systems: Travis County, Bexar County, Harris, Collin, Lubbock, and McLennan. So we're making some progress there. The Regional Public Defender Office for capital cases. I think you heard a little bit about them. You know, this started off as a small public defender in Lubbock County, just covering a handful of counties. And rural counties and mid-sized counties are allowed to opt into that. And they strictly provide death penalty trial level representation. How many counties is RPDO covering now? 185. One thing, Commissioner Ellis, a brilliant speaker, great senator, great commissioner. But one thing I would say he got wrong is actually Texas has more counties than any other state. Georgia, he's right, is actually second. Out of 254, we have 185. So we actually have more counties in RPDO than any other state has counties. 244, that's the number of counties covered by MyPedea now. So 244 of our counties, all but the largest 10, your attorneys have direct access to Pedea advisals. And we don't have enough people taking advantage of that. So one of the things I want to encourage you as a side note, if you're a defense attorney today, and you have any case that might have an immigration consequence, be sure to reach out to MyPedea. Get that Pedea advisal. Comply with the 6th Amendment to the Constitution. Now, one last category is monitoring. The Texas Indigent Defense Commission has done monitoring so far on the policy side. So this is looking at the compliance with the Fair Defense Act in 138 counties. Out of those 138, how many complied with the fair defense laws on our first visit? Unfortunately, 0. We've not yet been to a county where they were fully compliant with the fair defense laws on our first visit. But what about our fiscal monitoring? We have a fiscal monitor named Deborah. She's wonderful. She's a CPA. She goes out and she looks at expenditures for public defense in each of the counties. She's been to 144 counties. Out of those counties, how many on our first visit were complying with the fair defense laws? Better than the policy side, 3. We've had 3 counties complying. One last bit, appointments. Appointment rates are a really big deal. This is a really good gauge for us to tell how many people are getting an attorney. How well do we think we might be complying with the United States and Texas constitutions? If you look before the Fair Defense Act at felony appointments, the appointment rate statewide was about 62%. So in other words, about 62%, or roughly 6 out of 10 people who came into a criminal courtroom accused of a felony got an attorney. This is before the Fair Defense Act. Now that's up to 88%. So that's risen quite a bit. That's roughly in line with the national average. But that's felonies. What about misdemeanors? Before the Fair Defense Act, 27% of misdemeanor defendants received counsel. Now, some actually hired attorneys, but for the most part, we were seeing a lot of folks who just were uncounseled in misdemeanors. What's that number today? We've gone from 27% up to 49%. 49% of defendants who receive counsel in misdemeanor cases. That compares to about 80% nationally. So we're not quite where we need to be still. We've got a little bit of work to do on misdemeanor appointments. What's the takeaway here? I threw just a ton of numbers at you. We've made some progress in Texas, and where we are today is light years better than where we were 20 years ago. We're spending more. We have way more public defender offices and managed assigned counsel systems. We have better appointment rates, but as you can tell, we are still not where we need to be. We are not. The state has not really stepped up enough to spend the money, and a lot of that funding is still on the shoulders of the counties. The appointment rates are still, especially with misdemeanors and especially in rural areas, not where they need to be. We still have a lot of the state that's not covered by public defender offices. And we still have issues with quality and appointments. So we've got a lot of work to do. But hopefully that was a good introduction for you all to the state of public defense in Texas today. Now, again, for the rest of the present session, we're going to have 11 really good speakers talking about 11 different areas, and they're each going to have just about 5 minutes. It's going to be really quick. But man, I hope you find these topics as interesting as I do. So the first person we have up is Kelly Childress. So I'm going to hand it over to Kelly. Kelly's the Chief Public Defender for El Paso. So welcome, Kelly. I'll kick it over to you.
Thank you. Okay, let's go ahead and start with the slides.
So we're going to talk a little bit about public defender offices in urban counties. Most urban counties in Texas do have public defender offices. They tend to be the biggest offices, public defender offices in the state. I think we might have to click. It's not moving. There we go. So Harris County has the largest public defender office in Texas. Dallas County has the second largest. And the rest of these are not in any particular order. Travis County has a public defender office. Bexar County. El Paso County. And Hidalgo County. So about public defender offices, because public defenders in urban offices, because public defender and urban offices are paid a salary, our practice is not financially impacted by judges. So we're able to remain independent in that regard. Our appointment rates range between 10 and 60% of all criminal cases, depending on the county's indigent defense plan. We're often better equipped to address the client's needs that go beyond legal advice by having in-house teams of investigators, legal secretaries and paralegals, social workers, mitigation specialists, and sometimes even more specialties than that. And we usually have supervisory structures so that attorneys are not left on their own to handle everything. Caseloads in urban public defender offices tend at times to be higher and often fail to meet the standards of TIDC. But we're usually able to mitigate those higher caseloads through a more efficient distribution of workloads. So what I mean by workloads is that the amount of work that needs to be done on each case in a larger office can be spread out among a robust support team, which includes PDEA attorneys, mental health attorneys, investigators, legal secretaries and paralegals, social workers, and mitigation specialists. We're also able to tap into expert budgets to assist with preparation of cases. We have team environments in the larger offices with direct supervision. We're able to assign second and third chairs for trial work, which kind of spreads out the workload on those cases and helps with brainstorming. We are often able to employ technologies like electronic filing systems, automated reporting, and interfacing with other departments that makes our work a bit more efficient. And we tend to have more formalized training and continuing education programs. Additionally, urban public defender caseloads, can we click one more, sorry, even though they're higher, they tend not to be harmed by the higher caseloads. And there's been a number of studies that have shown that. For example, Dallas County, next slide. Sorry, I don't know why it's not advancing. People with mental illness had significantly more treatment contact and lower rates of recidivism when represented by the Dallas County Public Defender. In Travis County, the public defender had 47% of its cases dismissed compared to only 19% for assigned counsel. In Harris County, misdemeanor clients with mental illness were 5 times as likely to have their cases dismissed compared to those represented by assigned counsel. In Hidalgo County, the county was able to come into compliance with state rules by appointing the public defender in juvenile cases. In Bexar County, public defenders secured more mental health personal bonds than pretrial services recommendations alone did, avoiding over 3,600 jail days per year at $60 a day, which is approximately the cost of a jail bed in Bexar County. They saved the county more than $215,000 annually. And in El Paso County, a recent study indicated that across case types, the public defender got the same or better outcomes as assigned counsel at an overall lower price to the county. Some of the other benefits of public defender offices include more accountability, regular interaction with other justice partners. By having a public defender as a department head in a county, you regularly get a seat at the table when justice discussions are being had. We're able to take advantage of economies of scale, including county-funded office space and utilities that go with that. County departments that we can share resources with, such as the IT department and HR department, budget and payroll and purchasing. We're able to utilize in most larger counties, county equipment, such as copiers, computers, and anything else that an office needs to operate. We're able to provide health insurance and other benefits to public defender attorneys and staff members, and that contributes to employee retention. And we also are able to use internal libraries, subscriptions, and other resources for purposes of handling our caseloads. Of course, there's always room for improvement, and some of the things that the larger offices need to be working on is increased interaction and unity with the private attorneys in our areas. We should pay more attention to recruiting and retention. We can give more effort to caseload reduction, better transparency in reporting our data, more consistency in operations across the state of Texas, advanced training of all attorneys and specialty staff, employing more technological advances for quality and consistency within our offices, and more focus on holistic representation. Thank you very much.
Thank you, Kelly. Good to have you here, and good to hear about the urban perspective on public defense and how things are going. Next, we have Nicole Myessie, who is the Chief Public Defender and Director for the Public Defense Division for Texas Rio Grande Legal Aid, which has, Nicole, tell me if I'm wrong, 14 counties where you provide public defense, right?
Yes.
All right.
Correct.
Good to have you here. I'm going to kick it off to you. Good to see you, Nicole.
Good to see you. Good morning, everyone. I just wanted to start off by thanking TIDC and UT Law for inviting me to be part of this event. Coincidentally, I actually started my career in El Paso at the El Paso Public Defender's Office where Kelly is. I worked with her a little bit when she first came on board there. And I spent 10 years in El Paso. It was where I cultivated my passion in public defense. And so I'm just like really honored and completely humbled to be amongst all the speakers today and all you amazing individuals who fought so hard for the creation and passing of this critical legislation. I'm just completely in awe of you and the work that you've done. And so that being said, since I started in El Paso and I'm now with Texas Rio Grande Legal Aid, I have the perspective of, being part of a very well-funded public defender office. I believe that, in general, El Paso has a criminal justice system that I think, understands the importance of competent and indigent defense, and then and how important it is to properly fund the program. And then recently I came to Texas Rio Grande Legal Aid, and I spent the last around 8 months, learning the differences between a bigger city urban public defender's office, and then being part of a program where we have individual regional public defenders in rural communities, and it is very different, right? And so when I was thinking about what I wanted to speak about today, I had a hard time because although I have very passionate about this work, by nature, I think we're fixers and we focus on problems and solutions. And so I wanted to talk about, our victories, and it's important for us to celebrate them and know how far we've come so we can have hope that, progress will only continue from here. So that being said, let me give some background on TRALA and its history in rural Texas indigent defense. TRALA's Public Defender Program was created in 2006, thanks to the then Executive Director, David Hall, who also played a role in the passing of the Fair Defense Act and creation of TIDC. And thanks to the funding of TIDC, TRALA has been a key player ever since then in, altering the landscape for low income people who can't afford a public defense attorney, a criminal defense attorney. And so prior to the creation of TRALA, counties such as we service, the Beeville office currently services McMullen, B County, Live Oak County, Refugio County, and Goliad. Before TRALA was there, these counties had appointment rates of less than 10%. It wasn't uncommon for people to spend months in jail without ever having an attorney appointed to them, and then even longer to actually speak to their attorney. And so in South Texas, where public defender's offices didn't even exist, but also private bar, there's just a lack of private bar attorneys in these areas because the population is so small, and the community is struggles financially. TRALA now, now we're across in 14 counties. We provide holistic and zealous criminal defense to these counties. And we're as far as to the east is Harlingen and our Rio Grande City offices that service Star, Jim Hogg, Willacy. And then we have our central offices, which is in one of them is our newest program is Atascosa. And then the Beeville office where I started with TRALA services McMullen, B, Live Oak, Refugio, and Goliad. And then further east is our Hallettsville office, which currently services Lavaca County. And so essentially across all these counties, like I said, the TRALA and the public defender's offices are really the only option for these counties and for these persons to have an attorney appointed to them. It's a crucial service area. These counties are counties that struggle with lack of health insurance, county level poverty rates that are higher than even some of the national rates, and the isolation and distance from urban communities makes things like lack of mental health services, substance abuse services even more scarce. And so TRALA provides a broad range of services in these rural counties, such as we do the jail census monitoring for all the jails. So we are the ones that actually check to see if anybody was recently arrested. We go out and see them and do the applications for court-appointed attorneys. We help streamline the court process of court-appointed attorneys. We collaborate and work with stakeholders to try to improve the criminal justice system. And we are constantly trying to figure out innovative ways to deal with the lack of resources in these communities. One of our initiatives right now is also our peer specialist work and reentry work. Mr. Red Gilbert, he's going to be speaking to you all later. They're doing amazing things, and getting these judges and the prosecutors to actually consider alternatives to incarceration, and they're finding treatment programs outside of the community where clients can go to get treatment and help, and we've seen a lot of success with this initiative. And so I've spent the last month kind of going county to county and identifying what our needs are and try to figure out solutions. And so, we continue to face just a lack of resources, things like, lack of transportation, which is something that I think, even urban public defender office clients struggle with. Is, they're indigent, they don't have transportation, sometimes they don't have phones, but these things are kind of worse in these rural counties because sometimes they have to travel very far for their court dates to report on pretrial release, and there's just no public transportation to even help facilitate with that. Even if you were to get a client that wanted substance abuse treatment or wanted to actually address their mental health concerns, there's nowhere for them to go. That's, they have to travel 30, 40 miles, usually further, to get any type of treatment away from their families, away from their attorneys, away from their court proceedings that are still pending. And so, although, I think as a whole, I just think that, the isolation and the remoteness of these communities make it, a little bit more difficult. And so, and on top of that, I think the public defender's office in rural counties also are struggling a little bit more with recruitment and retention. All industries are struggling with that. but it's compounded here. And most of our attorneys aren't from these communities. You know, they're not from Texas. We have a lot of them from California. And so they're away from their families, and they struggle, you know, with their personal life and professionally. And so, you know, there's a lot of things that I think that we have to work on when it comes to rural indigent defense. The public defenders in the program are amazing. They're so passionate. You know, they come here, they really want to effectuate change. And then they're faced with, you know, counties that also struggle with their own budget issues, their lack of technology. There's a lack of uniformity amongst the counties on record keeping and information sharing. And we're developing different ways to deal with that. It turns out to be different processes depending on the county. We have to have different processes for each county because each county does things differently. And so our case management system has to be able to adjust to each individual county's case management system and process. And additionally, I mean, these counties are also dealing with workforce shortages themselves. This leads to jails that have lack of personnel for their administration. And COVID didn't help, right? We have a lot of jails that I think their jailers are struggling with COVID outbreaks. And so it's kind of creating a problem for access to the clients still. And so with Trala, we're constantly trying to figure out how can we use technology to help, you know, these counties with their lack of resources. And so, you know, if we can provide a laptop to the jail, then we do that. And we try to facilitate Zoom visits for the attorneys across the division. And so that's been very helpful. And I do think that overall, these counties are very grateful for us being there and providing the service that we do. Because I mean, we constantly hear about the way things were before Trala were in these communities, and the services that we provide for the citizens they're very grateful. Recently though, Trala, you know, we stepped up to defend, you know, more than 800 clients that are subject to Operation Lone Star, where hundreds of migrants are being arrested for simple misdemeanors and then housed in post-conviction prison units for months. And so, although I know we've come a very long way, we're in 14 counties, and we're having trials in counties that, you know, haven't had trials in a very long time. We're figuring out solutions to the lack of resources as best as we can. The work is not done, right? Not even close. And I think that we've reached a point where in society as a whole, you know, mass incarceration is being studied. Students are graduating from law schools and are passionate about fighting mass incarceration. They're leaving law school and looking for public defender offices. And we have organizations like TIDC investing in public defense. And they, you know, TIDC has been great about, you know, giving us ideas on how we can work around our technological issues and lack of resources. And so we're at a point where I think that, you know, we can look ahead, we can learn from from our mistakes, and where people, you know, maybe there's a future where people facing poverty, people of color, people whose lives have been torn apart by the criminal justice system for too long are actually able to be with their families, making memories. And so that's what we continue to fight for. That's what we're hoping, you know, will continue to progress criminal justice reform. And I just want to thank everyone for all the work that you do, and for the work that you have done, and you know, laying the foundation for all of this great work.
Thank you, Nicole. Yeah, Trala, you all have been doing amazing work. The appointment rates have shot up. The quality of representation has shot up. So we're very excited. And you all, there's a link to in the chat to Texas Rio Grande Legal Aid. Next, we have Shannon Evans, who's going to talk about managed assigned counsel systems. Shannon is from the Lubbock Private Defender Office. And Shannon, are you there?
I am. Can you hear me?
I can't see you. We can hear you.
Yep. Sorry about that.
There you are. Hey, welcome.
All righty, let me get started. Well, first off, good morning, everyone. Firstly, I'd like to say how thrilled I am to be a part of this day and to have the opportunity to present to everyone. I'm Shannon Evans, the director of the Lubbock Private Defender's Office. I'm a 9-year Air Force combat veteran, and I began my career journey within the legal system 10 years ago as an undergrad intern for Dallas County. Now, even though I could go on and on about how much I enjoy my position at, in a MAC, I can promise you, I can guarantee you it'll be short. Let's see. So it was about 8 years after the Fair Defense Act that the MAC concept for indigent defense was introduced to Texas. Lubbock County and the local defense bar began taking steps to beta test and to mainly beta test representing vulnerable clients with mental health special needs. So it only began with the special need clients. After about 2 years of this special pilot, the special needs office grew to what we know now as the Lubbock Private Defender's Office. In 2011, the office was given the full responsibility of administering indigent defense for all of Lubbock County's non-capital cases. Fast forward to the present, LPDO currently maintains a contracted panel with 80 private attorneys from the local defense bar. Our assignment coordinator hand selects counsel for an average of about 150 cases each week, including those with mental health diagnosis still. The foundation, I say, for the success of our office comes from the camaraderie of the local defense bar and their dedication to their clients. I often attribute the successes of our office to the fact that our office and defense bar is big enough to make waves within our system, but yet it's still small enough to know everyone's business. That next slide, Kathleen, that's the one. Okay. So in 2017, the office underwent a full administrative transformation from an office that was ran entirely with paper copies, fax machines, and a ton of check writing. We moved to a fully automated office that really puts an emphasis, or did put an emphasis on starting to capture that significant data. By doing so, we were able to measure our strengths and really analyze the weaknesses of the office. Since then, we've been able to quantify the impact that we have on our clients. We also were able to review our attorney fee schedules as they hadn't been reviewed for over 10 years. So we made a lot of attorneys happy by doing that. Fortunately, because of these advances, the office during the pandemic was we easily were able to transition and remain fully operational remotely. Currently, LPDO operates with 4 administrative team members, 5 forensic mental health caseworkers, and 1 private in-house investigator. One thing the office prides itself really is the collaboration that we have with the Texas Tech social worker program, where we continually have undergrad and master level interns working with us. This has really helped us cultivate our mental health program into a very high skilled mitigative team. So the benefits of the MAC offices are countless for Lubbock County. The relationships that we keep with the local agencies, they've really been pivotal to bringing change within our justice system. LPDO routinely presents to the police academy candidates, where we have this special small window to educate the local PD officers on our role as an indigent defense office and really the importance of crisis intervention. So to kind of drill down into LPDO's numbers, LPDO opens an average of about 9,000 cases per year. We budget for around 8,000 cases to be paid annually. We're continually looking always to innovate our services to the attorneys and to the clients. Our chief defender, he serves the panel by pairing mentors and mentees and helping attorneys through specific issues with collaborative staffing. We pride ourselves, and we're glad to be able to tell attorneys and clients and concerned families that no one goes to trial alone. LPDO schedules and plans CLEs for its attorneys all year long, ranging from mental health, competency, local resources, DWI. We currently have 15 panel attorneys that are qualified mentors. As soon as they are, as we get new attorneys, they're immediately assigned to sit second chair on higher level offenses. And this really helped ease the burden on our first and second degree qualified attorneys. To conclude, the passion to be in the field of helping society break from our generational cycles is really the driving force behind our mission. We know we can't change the world overnight or ensure that that each client, we can't ensure that we get to each client, but at least we can be a part of changing the course of someone's life. As always, I like to thank my team, my mentors, TIDC for your continued support, and everyone before me that's paved the way for change. I'm truly grateful. Thanks.
Thank you, Shannon. Thanks for being here. And Lubbock has really become a model for managed assigned counsel systems across the state and really increasingly across the country. So thanks for being here.
I appreciate it. Thank y'all.
I'm honored to present our next guest, Judge Chris Schuhart, who is the Medina County Judge. And in addition to that role, is really a leader among county judges and county officials statewide. So Judge Schuhart, thanks for being here.
Thank you very much, Jeff, and thank y'all all for being here. Just to give you a little background, I am the county judge for another 347 days, so I am on my way out. But prior to that, I also consider myself to be a recovering criminal defense lawyer. I practiced law for many years as a criminal defense lawyer and was very passionate as a criminal defense lawyer. When I became the judge, I continued, even though I have a county court at law judge, I continued to do criminal cases, and for the most part was very frustrated with not only the quality of not all lawyers, but many of the lawyers that showed up to take appointments in my court. And I'm in a county of about 50,000 people, but also frustrated with the fact that half the time they didn't show up. So about 2 years ago, I was in Austin at a TIDC meeting, was talking with Jeff, saw a presentation on public defender's offices. And I went back and gathered 4 of the counties that are in the ACOG district with me, and we talked about forming our public defender's office. We started with an interlocal agreement, the 5 counties. The board consists of 11 people, 2 from each county, the county judge or the county judge's appointee, and then another person from that county, and then Kirk County, which is our central located in county, gets 1 extra. So we have 11 people that manage this group. And when I say manage, the only person that we really manage is our chief public defender. Our chief public defender was hired in January of last year. In the first year, TIDC gave us about 80% of the funding for it. This year, it's dropped down to about 66% of the funding, somewhere in the neighborhood of about $2.2 or $2.3 million. And then the interlocal agreement provides that the counties pay the other part based upon their caseloads coming in. And in Medina County, what that equates to is we're going to spend about $224,000 a year on paying our share of the public defender's office to Kirk County. In the years past, before we started all this, Medina County was spending somewhere in the neighborhood of $350,000 to $400,000 a year on assigned counsel, outside counsel for indigent. And we still have to spend some of that because, and I've worked with Jeff on this, but we still have to pay for the people that are child protective services and things of that nature. That still comes out of there. So what have we got out of that, out of this funding from TIDC and then the 5 counties? I can tell you that besides the savings and money, and it's just now starting to show up because our public defender, we hired our chief in January of last year. He was full staffed in September of last year, 31 people, 21 lawyers, and 10 people, either secretarial, legal assistants or investigators. So our chief came in and he took it off running and has done an outstanding job. There's not a judge in our district, either CCL judge or district judge, that is not 100% satisfied with what's going on with our public defender's office. The indirect and intangible things that you see from this that are happening is we got We have less resets going on in our courts because every time a defendant shows up, there's a lawyer there for them if they're an indigent. It also means less court appearances for those indigents because they don't have to take off work and things of that nature. It also shows that we're having a reduced time from the indictment information phase to the time that that they get to resolution. And they're getting better deals. They're getting represented. I mean, they're getting great representation, and our jail population is also dropping because their time in jail is not as long. So I would say that to anybody out there that's trying to decide, do you want to do a public defender's office or not? I would say it's the money up. The money is there for the savings, but all those indirect benefits that we're getting currently, not only from defendants being represented properly to savings in our jail population, things of that nature, I would definitely say reach out and do it. If I can help you, we've got the templates for everything from interlocal agreements to how our board is made up. And I think we've done a pretty good job of putting it together. So with that, thank you, Jeff.
Thank you, Judge Shuhart. Thank you so much for being here today. And we're really excited to see the Hill Country Public Defender Office take off. So thanks for all your good work on that.
Thank you.
Next, we have Nathan Fennell, who is Nate is a staff attorney with the Texas Fair Defense Project and has done some really cool work in the past few years since he's been there. Nate, are you there?
I sure am.
Hey, good to see you.
Thank you. You too. So I'm here to talk about oversight of the indigent defense function in Texas, and particularly local systems. So not what TIDC does with their policy overviews, but locally. And I want to talk about why more counties should think about this and explain some current practices. And I think one of the big takeaway points is that in individual cases and with individual lawyers, the judge presiding over a case should be the last resort and not the first response. So the importance, Commissioner Ellis talked about the ABA principles, and pretty much anyone who has seriously studied and thought about indigent defense has said that that independence is one of the most important things about an indigent defense system. The United States Supreme Court went as far as to say that you shouldn't even think about court-appointed lawyers as government employees at all. We should think about them the same way we think about privately retained counsel. They work for the defendant. They do what is best for the defendant. And the problem, once we start thinking about independence from the judiciary, is that you also need to make sure that lawyers are going to be able to be responsive to their clients, right? In a lot of counties in Texas, what we essentially have is a series of independent contractors providing this necessary constitutional provision to defendants. And it's important to note that this is a structural question. Even if all the lawyers in your county are doing amazing jobs, you still need a government structure to make sure that the contractors are doing the work that needs to be done. And even if there's only one person who's not doing the work that they're supposed to do, that could affect a lot of clients because one lawyer could have a really big caseload. And I think having oversight structures is also important because in reality right now, in places where there isn't much of a local oversight structure, defendants that have issues with their court-appointed lawyers are turning to the state bar ethical procedures, and they're filing grievances against lawyers. And I think, having a more effective and robust local oversight system could lead to fewer of those ethical complaints against lawyers that are doing the right thing. And obviously the disciplinary rules of professional conduct are not the same as the kinds of responsibilities that are necessary to provide someone effective criminal defense representation. So to talk about current practices, in a lot of counties, like I said, there's not really a system designed for these things. And so it kind of falls back on just the judge presiding over a case. If a judge gets a request from a defendant about that claims they're having issues with their court-appointed lawyer, that they are required to look into that and have a hearing on it, probably an ex parte hearing with a sealed record. But a lot of judges aren't doing that. And in part, it's because it's really hard to maintain this role, the independence, right? It's hard to be the independent arbiter over a courtroom and also be responsible for one half of the representation in an adversary system. That's a difficult position to be in, both as an individual and, again, structurally, it can create kind of the appearance of impropriety to have the lawyer for one side talking about their interactions with their client and maybe even talking about strategy stuff. So some counties that have dealt with this in various ways. So there are obviously, like Judge Schuhart was just talking about, in counties that have public defender offices, the lawyers who practice in court now have a boss. There's a supervisor. People can talk to the people in the public defender office about what's going on. And that can provide both some oversight and also it can provide some training and help if what people really need is just a little bit of support for one thing that they might benefit from a little bit of help on. There are managed assigned counsel offices that also do this. I think that different offices in the state have different levels of oversight that they exert over the lawyers practicing in their courtrooms. And I think some look into people's use of investigation and social work resources that are available. They look into any complaints they might get. They watch people in court. They supervise them at trials the way that we heard about in Lubbock. And that can be helpful. I'm sorry. And finally, there are some indigent defense coordinators that have been doing really good work, making sure lawyers visit their clients, making sure people are billing the right time to do things they need. And all those are some useful things that people are doing in the state. Thank you.
Thank you, Nate. That's really helpful. I mean, there's so much we need to do, so much more we need to do in terms of structure and oversight and supervision. So I appreciate it. We next have Alex Bunnen, who is the Chief Public Defender for Harris County. And Chief, I think Alex, for what was it before Harris County, 2 other offices or 3?
Yeah, I've opened 3 or 4, actually 4.
4, yeah. So talking about an issue I know that's near and dear to your heart, performance guidelines and caseload limits.
Yeah, I was given 2 topics, both of which cannot be adequately discussed in 5 minutes. But what I can tell you is there's some very good comprehensive materials that I'm going to point you to that'll help you with that. Can you give me my first slide? Great. So this book, Securing Reasonable Caseloads, Ethics in Law and Public Defense, was written by the late Dean Norman Lefstein, who's near and dear to many of us in Texas. He came down and worked on our Texas caseload study that was pursuant to House Bill 1318. A great man who knew more than anyone on this subject. This book is probably close to 300 pages, but it's free. If you just Google the name of the book, it'll take you to the, well, I think Jeff just put it in the chat, but if you Google it, it'll get you there. If you hit any paywalls or anything, I'll put up my email in the chat and you can get it from me, but it's a free book. And if you took one thing from this book, Norm Lefstein did some math. He figured out that the average lawyer has about 1,850 working hours a year. And the way he got there was just excluded holidays, weekends, minimal sick and vacation time, and averaged a little bit more than a 40-hour week. And he figured that that's about the max amount of time you have, maybe a little more, maybe a little less. So to figure out how much time you could spend per case, all you got to do is divide how many cases you have from 1,850 hours. And there are a lot of lawyers across the United States, here in Texas, here in Harris County, who have more than 500 appointed cases a year. And what that means is they can spend 3.7 hours on each case. Now, I've heard lawyers say, oh, I'm very experienced. I can look at a case and I can decide what to do on it. I can save all kinds of time. Well, that might work some of the time, but over time, you're going to make mistakes. And those mistakes end up in injustice. And that's how we get all the travesties that we see over the years when people have to file writs later and undo things and exonerate defendants who were the subject of those mistakes. Now, the Texas study came up with about an average for felony cases of about 128. So a lawyer could spend as much as 14.4 hours on that if they were following those guidelines. And that in a public defender's office, that also means they have the help of investigators, social workers, and other administrative, so that you're basically multiplying the ability to work on those cases. So caseloads are really important. If you don't do them right, then the clients are going to suffer. And there's a real difference between workloads and caseloads. Caseloads are just the number of cases you have. That doesn't tell you anything about them. They could be very complex cases. If all your cases are murder cases, you're doing a lot more work and have a lot more work to do than people are doing probation revocations. Workloads mean not only the complexity of the case, but all the other work you do in your office, in a public defender office, or even a private assigned counsel. You have other things you have to do than just the cases that you are assigned. You have administrative tasks, you're helping other lawyers. In our office, we put on tons of CLE for the bar. So there's all kinds of things that need to be factored in when you do that. And the Texas caseload study did do that. So those are very helpful guidelines to go by for caseloads. Let's go to the next slide. So the other topic I got was, we call it performance standards. Here in Texas, they're performance guidelines. Back in 2011, the Texas Bar's Committee on Legal Services to the Poor and Criminal Matters that you heard about before, Janie Misselli's current chair. Back then, it was Andrea Marsh and Jeff Blackburn who were the primary authors of what you see over toward the left, the Performance Guidelines for Non-Capital Criminal Defense Representation. Those are very comprehensive guidelines. They're available. That committee has now revised them. They're going to be printed in the Bar Journal in April. So to look for those. And why do you need them? Well, they remind you to do stuff. Client contact, investigation, research, motions, objections, ethics. They're not the law. They're not rules. They don't have the effect of ethical guidelines, but they're really good and best practices that you should follow. And they're a great reminder in any case of what you should be doing. So they're an asset to you, and go ahead and read them. Thanks, Jeff.
Thank you, Alex. I'd say you did pretty darn well in 5 minutes. You got a lot across. And I agree with Alex. If there's one thing you're going to read about caseloads, Norm Lefstein's book, which is in the chat, is the way to go. And yeah, really check out the performance guidelines. That's a big deal. ABA defense function standards, kind of same thing. Tells you what you should be doing. It's a good reminder to investigate, research, talk to your client, file motions. So thank you. That's very helpful, Alex. I like your tie too. Next, we have Carrie Ellis. Carrie, welcome. Carrie is the training director of the Harris County Managed Assigned Counsel System and has done a ton of training across the country, but today's talking to us about mentoring. So welcome.
Thank you. Thank you. I want to talk a little bit about mentoring and mentorship programs. We know that there are lawyers who are committed to indigent defense. They have a passion for it, and it's the work that they want to do, but sometimes may feel that they can't. They may not yet have enough experience. They don't know how to get involved with it. Or you could have attorneys who are doing it already, and they want to continue to grow as a lawyer and develop their own practice. And so in Texas, there are mentorship programs that are available, some at more of a county level or at a state level, that work with and support attorneys. And when you think about these programs, I think they're sort of really moving towards two goals. One is to provide lawyers with access to resources and guidance and training so that they can develop the knowledge and skills to provide high quality representation. But also mentorship programs connect lawyers to a support system and build a community of lawyers so that they have people they can turn to when they need help with their cases or just sort of sustaining the practice, which we know can be really difficult. The programs that exist can be structured and are structured in different ways. There's a sort of traditional, when you think of a mentorship program, of a one-on-one relationship where maybe a newer attorney is paired up with a more experienced attorney, so that that new attorney has someone that they can, not feel bad about bothering or ask questions about, brainstorm cases. There's, programs that allow people to second chair with more experienced lawyers so they can get experience in trials or in hearings. And then there's, outside of the one-on-one programs, there's sort of more group settings where the mentoring happens in that group setting, where, you know, a group of people get together, both experienced and newer lawyers, to strategize or brainstorm cases. And, you know, most programs, I would say, kind of include a hybrid of those. And while these, you know, sometimes when you think of mentorship programs, you think of an opportunity for new lawyers, and certainly that is a way, but also there are lawyers who have experience, but may be wanting to look to take more complex or more serious cases. Especially in some of the counties you heard Shannon talk about in Lubbock and in Travis, you know, where for people who take appointments through the court or through managed assigned counsel programs, you know, in order to take more and more serious cases, you have to meet qualifications, and those can be hard to get. And mentoring is a way for attorneys to be able to get exposed to and experience with more serious cases in a supportive environment before they take on the responsibility of handling those on their own. I wanted to briefly just highlight sort of an example of Texas. One is one that TIDC, Texas Criminal Defense Lawyers Association, Harris County Public Defender's Office has been, which now is called the Future Indigent Defense Leaders Program, where they have paired with Gideon's Promise, which is a national training program for people who provide indigent defense, and to select lawyers from across the state to be able to participate in a training and mentoring program where they get an intensive, you know, initial 2-week training program, and then over the course of 3 years come together about every 6 months for additional training. And those programs, that kind of program, both helps develop the skills, but also those connections, and not just connections within your own county or community, but across the state, which can really help lawyers in their practice for that. And then at a more local level here in Harris County, we at the Office of Managed Assigned Counsel, and our next month will be starting our misdemeanor mentorship program, which is a 12-month program for new lawyers, for lawyers who want to practice indigent defense, but, you know, are newer and so don't yet have a year of experience practicing criminal law. And so it's a way for people who have this commitment to be able to take a limited number of appointments, but to ensure that clients are getting the kind of representation is that the participants in this program participate in initial training and monthly training that talk, you know, substantive law and skills, but also they're paired up with a resource attorney in our office to meet regularly. You know, those are just 2 examples of some mentorship programs that exist in Texas, but there are others. And I think what's exciting is that these programs continue to grow and will continue to grow so that, you know, people who are committed to indigent defense have access to the training and support network they need to sustain to do this work, but also to make sure that clients are getting the representation. So thank you.
Thank you, Carrie. This stuff is so important. We don't graduate law school knowing how to practice law, and mentoring is just so important in the public defense arena. So very glad you're doing the work that you're doing here in Texas. So up next, we're going to talk about counsel at first appearance, counsel administration. This is a big issue. I think we only have maybe 7 counties right now providing counsel at first appearance in Texas. And we're very fortunate to have with us a wonderful researcher and attorney from Harvard, Renee Danzer. Welcome, Renee.
Thank you. Okay, we can go ahead and get started. So each year, the US detains approximately 7.8 million people pending trial. We know that indigent detainees are disproportionately people of color accused of nonviolent crimes. Next slide, please. At first appearance, a judge makes a determination regarding an individual's liberty pending trial based on a number of things. A few of those things are the perceived risk of failing to appear and the public safety risk that that individual may pose. So in order to be released, bond of some sort is usually required. Often that's monetary, sometimes other conditions that result in fees on an individual's case. Sometimes there's the ability to be released merely on the promise of attending the next court hearing. Sometimes this means that if you're poor, you don't get out. Next slide. So does a lawyer make a difference in these hearings? Next slide. My name is Renee Danzer, as Jeff told you. I work at the Access to Justice Lab, where we conduct rigorous research into initiatives designed to increase access to justice in the legal system. Right now, we're working with the Public Policy Research Institute at Texas A&M and Dr. George Nafal to study counsel at first appearance in Texas. Before I tell you what we're doing, I'm going to tell you what's already been done and what we already know. Next slide, please. So there are 2 randomized controlled trials of counsel at first appearance that have been completed. RCTs are often thought to be the most rigorous of studies that lead to most conclusive of evidence that can be grounded in the random sorting into groups that render those 2 groups identical, but for what you're studying. And in this case, that's the effect of counsel at first appearance. The first of those RCTs was conducted by the National Institute of Justice in 1985. The second was conducted by the Lawyers at Bail Project in 1998. Next slide, please. There have also been 3 observational studies conducted in upstate New York. Observational studies are less rigorous than RCTs sometimes, but they still are rigorous and generate very usable and good evidence. In 2017, the New York State Office of Indigent Legal Services released results from a rural study. In that study, they observed proceedings and reviewed documents to develop their findings. In 2018, a before and after study was done that analyzed case record data from before and immediately after the implementation of counsel at first appearance. And in 2020, a very similar before and after study was completed. Next slide, please. So what did we learn from these studies? Next slide. The presence of counsel at first appearance seemed to improve the attorney-client relationship. That was the first lesson. Next slide. Next, when given an attorney, individuals were more satisfied with the outcome at the bail hearing and their treatment by the judge. They thought the presence of counsel influenced the bail decision. They were more likely to believe the judge acted respectfully toward them, considered their side of the story, and that they were able to influence the decision-making process. Next slide. Individuals who received counsel tended to be released pre-trial earlier than those who do not. Next slide. Cases with counsel present resolved more quickly often. Next slide. And then also when the presence of counsel leads to pretrial release or promotes early case resolution, that in turn can translate to cost savings for the justice system on the whole. Next slide. And then finally, the economy as a whole may benefit when individuals are released. Those who are incarcerated are often at risk of losing jobs and facing eviction, and their families lose an economic provider or a child caretaker, all of which can have downstream and negative effects on the overall economy. Next slide. Now that we know what the study suggested counsel at first appearance did do, let's see what counsel at first appearance did not have an effect on. Next slide. Counsel does not appear to affect the percentage of individuals who make confessions without the advice of counsel. Next slide. Counsel also didn't seem to impact the preference of clients for privately retained counsel. Now, the only study that reported on this was the NIJ study, and that was done in 1985. So it is a little dated, but it reported there was still a preference for privately retained counsel over a public defender, even for those in the group that received counsel at first appearance. Next slide. Our research hopes to contribute to this research with a randomized control trial in Potter, Hayes, and Travis counties. We've completed randomization and are now analyzing data for the Potter and Hayes County experiments. We'll start the study in Travis later this spring, hopefully. We're looking at whether CAFA affects the bond type and bond amount, time to disposition and sentence, failure to appear, and recidivism. There'll be a cost analysis and also some qualitative analysis of attorney and judge and court staff impressions, as well as defendant impressions. Thank you, Jeff.
Thank you, Renee. Thanks for being with us today. This is important stuff. Like I said, I think only a handful or a little bit more than that of counties that have counsel at first appearance here in Texas. So your research is hugely important. So I can't wait to see what we find out.
Thank you.
Next, we have with us Krista Harvey. So Krista's going to be talking about Padilla versus Kentucky. And Krista, it's been 12 years since Padilla?
I think so.
I'm anxious to see how things are going in Texas. Are we find out if we're complying?
Yeah, Texas is doing just a great job. So as we've heard, there's a lot of cases and arrests in Texas, an overwhelming amount. But I want to look at the immigrant population in those cases. A lot of the times, I'm sorry, Kathleen, next slide. The next one. There we go. It's a very helpful diagram. of the immigration deportation process that starts when the ICE detainer is issued. So what that means is the sheriff contacts the local ICE office and says, hey, we have this guy, he says he's not a citizen and he's charged with X crime. And then ICE says, okay, either they do or do not issue an ICE detainer, and they say, okay, we're gonna put a hold on this guy whenever he is done with his sentence or he bonds out. Don't let him out because we're gonna come get him and we're gonna take him to ICE detention. And I just wanna note that ICE only has 48 hours to do this. So if ICE doesn't act on their detainer in 48 hours, the jail has to release them. There's no motion required, they have to let them out. So once ICE acts on that detainer and they do come pick them up in that 48 hours, they are taken to the ICE processing facility. They are fingerprinted, put in the system, all of that stuff. The ICE officer could offer them an immigration bond at that point, or they go to the immigration detention center and they face the judge at that point. And next. And the stats show there's approximately 31,000 ICE detainers issued in the state of Texas. And that is enough people to fill the entire UNT football stadium. Whether or not that's actually been done because the UNT football team seems lackluster, but it is also the entire population of Nacogdoches. And not every non-citizen gets a detainer. Some people get lucky. But we know that there are over 30,000 people placed in removal proceedings because of an arrest in an ICE detainer or some sort of flag. And that's why it's important to start the immigration case planning as soon as the person is arrested and not wait until they're already in ICE custody. It's also important to remember that there are no court-appointed attorneys in immigration court. So a lot of the times their criminal defense attorney is the last person that they have contact with. 63% of non-detained defendants are pro se, or respondents are immigration's words for defendants. And 86% of detained respondents are pro se. So it's really important that they have some sort of idea from their criminal defense attorney what they're walking into, if they do. Understandably, most people, citizens or non-citizens, do not understand the immigration process. They think that they could be deported by a county judge, or they don't have any standing in removal proceedings, or they have a green card and they don't think they can be deported because they have papers. And they don't realize that even having a small amount of a controlled substance can get a person deported. And now next slide. And that's why Padilla v. Kentucky was started. Mr. Padilla was a Vietnam veteran. He lived in the United States most of his life. He had a card for over 20 years, but then he was charged with drug trafficking. And his criminal defense attorney said, oh, don't worry about it. There's no way they could deport somebody like you. You're a veteran. You contribute so much to the nation. The plea is safe. Don't worry about it. And then there's a little animation if you click again. Yeah, worked hard on that one. So Mr. Reed took his advice and he got deported. And he appealed his case all the way to the Supreme Court. And the Supreme Court established obligations for the criminal defense attorney to warn their clients. And the warning must be specific and detailed if the consequences are clear. And next slide. And if the criminal defense attorney fails to do that, that is grounds for an ineffective assistance of counsel claim. And the criminal defense attorney has a lot going on, even without an immigration issue. And they shouldn't have to play both roles. Next slide. That's out of order. Next slide. And in response to this, to fill this gap in representation, there are Padilla attorneys like myself that work with the criminal defense attorney and the defendant to see how we could possibly mitigate some of the immigration consequences of a conviction. So, let's say that there's an assault case. Let's say the guy got his green card 6 months ago, but he was convicted of intentional and knowing assault with a sentence to imprisonment of a year or more. That person is placed in proceedings with no relief available. But if he was convicted of reckless assault, he would not be placed in proceedings at all. So that's why they're important.
Thank you, Krista. So, I mean, real quick, I mean, if you're a criminal defendant who's listening right now and you're not talking to Padilla attorneys, is it safe to say there's close to 100% chance that you're violating the Constitution?
Yes, yeah, it is a violation of the Sixth Amendment.
Yeah. So defense attorneys, check out My Padilla. We put a link in the chat. And Krista, thank you so much for being here. I appreciate it.
Sorry, I went a little long. Thanks.
No, I love your graphics. I love the animation.
Thank you.
Next, we have with us, our second to last speaker, Red Gilbert, who is a peer specialist with Texas Rio Grande Legal Aid. Red, come on down.
There you go. My name is, well, thank you, Jeff. My name is Red Gilbert, and I work for Texas Rio Grande Legal Aid. I've been here for 4 years. I am a caseworker, reentry peer specialist. I'm on the board of directors for the South Texas Recovery Foundation, and I'm also on the mental health planning committee for HHSC. So I'm pretty lucky to be where I'm at and be doing the things that I do. So Jeff asked me to speak about what peers do and what their role is in the public defender office. I'm assigned to the B County, the B Public Defender's Office, and we serve 5 counties. How do we pick our clients and what do we do when we engage our clients? Our clients are, for the most part, all Axis 1 mental health, significant issues going on with them, or they're very involved in substance abuse issues. We move forward with that, trying to get them engaged and help to advocate for them for alternatives to incarceration, something other than to sending them to prison. And the reason that we work so hard at that is that the judges and the attorneys and the prosecutors all for a long time have wanted something other than to send somebody to the prison and give them an alternative to place to send people. So what we work at is we work to send people to treatment programs. We find alternatives to something for long-term mental health. And we work with all kinds of clients. We work with people that are misdemeanors from possession all the way up to murder. There's been a definite need for this for a very long time. And what we do is we engage the client right after they're arrested. We have people that go to the jail that do intakes. And those people then will refer them to us if there is a need or there is a history of mental health issues or diagnoses, or they admit to long-term substance abuse issues. And then we engage them starting as quickly as we can, and we continue to walk them through the system. Because the system, as we all know, is pretty daunting. I am an ex-offender. I went to prison. I was arrested multiple times. And I can tell you that my ducks were in a row, and it was difficult for me to navigate the system. And many of our clients have to learn to navigate that system while they're coming down off of drugs, or they're suffering with mental health issues that cause them to see or hear things that aren't there. I mean, it's a very difficult system for them to get through. What we do, or what we try to do, is make sure that they understand everything that's going on with the prosecution, with the judges, and with their own attorneys. And we also make sure that the opposite is true, that the attorneys, the judges, and the prosecutors all understand what the client's trying to do, and we all work together. And the reason it works so well for us in the counties that we're serving here is because the judges and the prosecutors got on board with it. They were very responsive to what we wanted to do, what we were looking to do. And they wanted that alternative. They wanted another option other than prison. The clients are very responsive for the most part. We work really, really well, where the attorney would meet with the client, however many times leading up to going to court. We see the client from the day we engage them. We start seeing them at least 1 to 2 times a week, sometimes more, depending on the severity of their situation. We have a tendency to follow the clients for up to 3 years after they're out of the program or if they're out of our control, just to help them navigate anything else that comes up. Now that's optional for the client. The clients don't have to keep engaged with us, but a lot of times they choose to. Over 2020, I worked with over 60 clients and had over 650 engagements with those clients. So there's a lot of work goes into working with each of the clients going toward court and helping them to understand everything that's going on. It's a great asset to the public defender office because the clients have somebody they can talk to that they know has been where they are. And I appreciate the chance to talk to everybody.
Thank you, Red, for joining us. I mean, what you're doing is so cool. And does memory serve that some of your work and Lori's was even covered in the New York Times just a couple of years ago?
Yes.
So you all are doing really cool work and having a big influence. I appreciate your time.
Thank you.
Last but not least, we have Annette Price. Annette is the co-executive director for the Grassroots Leadership, and she's going to be talking about community engagement. So welcome, Annette.
Hi, thank you all for having me. My name is Annette Price, and I am one of the co-executives of Grassroots Leadership, and I'm also directly impacted by the criminal justice system. Public defense is so important because at the core, it adds support to a person who is facing an inherently unjust system. However, when PDs are only willing to confront individual cases and unwilling to make systemic correlations, things can go really wrong. Public defenders have to be aware that there's a power discrepancy when it comes to them and their clients. While it is their role and their focus to get a person out, understanding the communities that they are serving and seeing their inherent value and lived experience as expertise for their holistic defense can be a challenge. Participatory defense has been born in part because of this issue, but it still requires work on part of the public defender to instill a culture where there's welcome. And precisely because there is a culture aspect to this, it has to be part of any defense system. In our experience, community organizing is widely misunderstood with many public defenders. People with lived experience can offer much needed systemic reform, and community groups are hubs for people with lived experience to come together and find collective solutions to systemic issues. What starts at the individual level is rooted in some kind of systemic failure. But since in CJ systems are largely based on the law and the construct of guilt or innocent, both with racist and oppressive origins, community organizers still need the expertise of someone who is not trying to use the system against them. We've been most successful with systemic impact when people like public defenders understand this and use their access and knowledge and know that they are not expected to take on the role of an organizer, but in order for the defense system to actually improve, there's much that can be done to support the role of their client or an organizer in systemic approaches to individual cases. Like for instance, in Harris County, people are having issues with judges restricting. Systems mirror larger systems, and feedback is often not well received because it's hard to see ourselves as part of an inherently flawed system when we enter it with good intentions. But for us, we are all actively participating in an unfair system, whether we acknowledge it or not. At the policy level, public defenders are extremely underfunded and under-resources, and we fully understand that. Because the priorities of our current system are carceral-centered, we also get involved in policy and practice changes for those reasons. Operation Lone Star helps illustrate the challenges with public defense, especially in states like Texas. Public defense is being used as an enabler of an already unjust system and weaponized to enact another unjust system, which is the immigration system. It is highlighting how a defense that is not holistic, for example, the lack of universal representation to confront the immigration system, will inevitably fail people. It shows how resources can be restricted. But I ask, can a system run by the very source that is funding the attack actually be part of a defense? My understanding now of an assigned public defender is different today than when I was assigned one for my case. A lot of what we do through the public participatory defense is to break down systems for families in a way that is accessible to them and also accompany them through what is a very vast and terrifying system. Participatory defense asks, what did you lack most in your time of need instead of, did you do what you're accused of doing? And if so, why? At the end of the day, people who are accused or committing crimes are full people with full lives. The first thing the system does is to box us into one narrative as a criminal. What we do through participatory defense is to make sure that the wholeness of the humanity of the given person is not lost, and that all of the full content of the person's lives is brought into perspective, because not only in that way, but we will get to address the fundamental issues of conflict, violence, and harm, but not just punish and disappear people. But that changes the way we relate to each other to get to the real accountability, restitution, and rehabilitation. If public defense was rooted in a lot of that culture, many of the layers of the system that don't allow public defenders to fully thrive in their profession would, in our opinion, begin to unpeel. Thank you for that.
Thank you, Annette. Thanks for being here today. There's a lot more we need to do here in Texas for public defenders to see our clients remember their humanity and everything. Like you said, see them as full people. So I appreciate the work you're doing, and a lot more public defenders and frankly TIDC can do to work with community organizations. So I appreciate your time here today.
Thank you for having me.
So folks, that is the present. Hopefully that gives you a good whirlwind tour of the present state of Texas public defense. We went just a few minutes over, so we're actually gonna break until 12:10 and then come back for the future of Texas public defense. And the panel, the lineup's pretty darn good. So hope you're back with us at 12:10. Grab a sandwich, grab a drink, come on back at 12:10. We'll see you in just a bit.
Afternoon, all.
Howdy, Andy.
Howdy. May I ask, can you guys hear me all right?
Yes, sir.
Yes,
Perfect.
I can hear you.
Thank you.
Yeah.
All right, we're ready when you are, Professor Davies.
Oh, thank you. Yes, certainly ready to begin. Much appreciate the introduction. And are we live with our audience at the moment?
We are live.
Thank you so much. Welcome and thanks for being here, everybody. It's very exciting and a great honor, certainly for me personally, to be here on this panel with the assignment to talk about the future of indigent defense services in the state of Texas. My name's Andrew Davis. My position is that I'm the research director at the Deason Center for Criminal Justice Reform, which is based at the SMU Dedman Law School. As you may have noticed, I'm not a native Texan. I am somebody who has education in criminal justice as a researcher, and I served for several years in New York State for the New York State Office of Indigent Legal Services, which is a statewide oversight body not dissimilar to the Texas Indigent Defense Commission. I also serve as the president of the Indigent Defense Research Association. So as a researcher, I'm very interested in, as a researcher who focuses on indigent defense working in Texas, I'm grateful to be here for lots and lots of reasons. And one is that I have personally benefited from, and I'm so grateful for the work of the TIDC, which of course produces so much data, which has already meant that across the last 20 years, Texas has really become a leader in transparent data around its indigent defense system. There's, of course, so much work still to do, but there's probably not another state that does as good a job with producing meaningful and transparent data about indigent defense right now than Texas does. So it's an extraordinary place to be. And it's been delightful, really, to hear about the history of the last 20 years from our several expert and esteemed panelists from earlier in the day. I know I've learned a lot, and it's certainly already stimulated me to think a lot about the future, which is in fact our assignment. It's actually very rare, I think, for us to think broadly about the future in indigent defense. And it's also pretty rare to have this kind of scope of timeline. In our discussions with this panel before this event, we took from the assignment that was this the 20-year anniversary of the Fair Defense Act, we ought to be looking forward to the year 2042. What will indigent defense in Texas or public defense look like in 20 years from now? And I think that one of the things that I've taken away more than anything else is that if you give yourself 20 years, a lot can happen. We're not necessarily talking incremental reforms here. We're talking paradigm shifts. And so it's a wonderful moment in a way to take this hour to step away from our day-to-day conflicts and woes where we're, trying to eke out a little bit over here or a little bit more over there, and think about really what are we all about, and what are we really aiming for? And let's untether ourselves from the present and the past if we can, and try and imagine what the future really would look like. I am excited to be here with this panel of speakers today. I'm sorry to report that one person that we were hoping to have with us, Chiara Cooper, cannot be with us because of a family emergency. And we are thinking about you, Chiara, and we will talk with you again soon. But we do nevertheless have an extremely strong and exciting group with us here. So I'll take a moment to introduce everybody, if I may. First, we have Maggie Luna. Maggie is the Hogg Foundation for Mental Health Peer Policy Fellow at the Texas Center for Justice and Equity. She's focused on creating advocacy opportunities for system-impacted Texans. Her own passion for justice policy is fueled by her lived experience with the system and with the criminal legal system and substance use, including incarceration at state and county levels in Texas. A year after her release from prison, Maggie began advocating for a host of women's dignity bills, and throughout Texas's 2019 legislative session, she encouraged lawmakers to support reforms, including regarding conditions of confinement. A graduate of the Smart Justice speaker at Texas Southern University's Thurgood Marshall School of Law, Maggie coordinates the statewide leadership council, which TCJE launched to elevate the voices of system-impacted people in local and state policy reform. Welcome, Maggie. Thank you for being with us. We're also delighted to be joined by Adeola Ogunkeyede. Adeola is the first ever Chief Public Defender for Travis County, Texas. She previously served as the inaugural director for the Civil Rights and Racial Justice Program at the Legal Aid Justice Center in Virginia, where she worked to reform the criminal legal system's over-reliance on incarceration and perpetuation of racial inequity. She also co-taught the Civil Rights Clinic at the University of Virginia Law School. Adeola was awarded the 2020 Kutak Dodds Prize by the National Legal Aid Defender Association for demonstrating a genuine commitment to bridging the gap between civil and criminal legal systems and to ensuring that community lawyering and racial justice are at the core of her work. She was a 2019 fellow with the Shriver Center's Racial Justice Institute, a leadership program that equips advocates to address the role that racism plays in causing and perpetuating poverty. Adeola was also a gubernatorial appointee to the Virginia Indigent Defense Commission and the Commonwealth Commission on Diversity, Equity, and Inclusion in the aftermath of the tragic events in Charlottesville. Prior to her time in Virginia, Adeola was the Director of Staff Development and Litigation Supervisor of the Criminal Practice at the Bronx Defenders, and she's also a founding member of the Black Public Defenders Association. Welcome, Adeola. Good to have you here. We also have Joe Stevens. Joe Stevens is the Chief of the Concho Valley Regional Public Defender's Office in San Angelo, Texas. His office covers 7 rural counties. Before that, Joe spent time at the Public Defender and Bethke. He's also worked on appellate and post-conviction issues under Justin Brown in Baltimore, an attorney most known for his work representing Adnan Syed from the Serial podcast. Joe went to UT Law and received his undergraduate degree from Vanderbilt, where he was on scholarship. He's also an 11-time Ironman triathlete and a board member of the Texas Criminal Defense Lawyers Association. One or the other of those requires great endurance, I'm sure. Welcome, Joe. Thank you. And last but not least, we're joined by Amanda Woog. Amanda is the Executive Director of the Texas Fair Defense Project. Texas Fair Defense Project fights to end criminalization of poverty in Texas. And as an anti-racist organization, it works through litigation, advocacy, and community lawyering in pursuit of that goal. Thank you, Amanda, for joining us also. All right, so in preparation for this session, I asked all of our panelists to think about the question, what should indigent defense in Texas look like in 20 years? And then after I asked them now to give their answers to that question, I'm hoping we'll have a sense of the different visions that could exist for Texas in the next 2 decades. And after they outline those visions, I'm then going to ask them what role 3 institutions can play in bringing that vision into reality. The first institution I want to ask about is the government, whether the state or the county government. And the reason I want to ask about that is because I have a theory that the government is a key decision maker in determining what indigent defense looks like. In particular, most saliently, it decides how much money to spend on it. So if we are as a future vision of indigent defense services, it's going to have to involve a decision by the government about how much it would like to spend and how it would otherwise like to regulate and oversee and organize the defense function. The second institution I'd like to ask about is judges. And the reason I'd like to ask about judges is that it is judges who, in the law and certainly in practical matter, are the ones who allocate indigent defense lawyers to cases. And so if judges were to choose to allocate and give indigent defense services to people in a different way, that would change the kinds of services that we have in Texas. And so they are another key decision maker that can cause this service to be to expand or contract or to be delivered in different ways. And third, I want to ask about defenders themselves. Defenders are a key decision maker in the kinds of defense services that are delivered in Texas because they deliver those services directly. And if they delivered them directly, then Texas would have different indigent defense services being delivered. So in the spirit of trying to look forward and in the spirit of trying to think about decisions and planning, I want to ask about those 3 institutions in particular. But first, I should return to the original question, which is, what do we think indigent defense services should look like in Texas in 20 years? And I'd like to start with Maggie, if I may.
Thank you, Professor Davies. So I've thought about this question a million times, thinking that in a perfect world, it wouldn't be necessary. We would have restorative justice and poverty would be a thing of the past. Because from my experience, poverty is what drives most of the legal system. If you don't have money for an attorney, money to get out bond, then you're more than likely to accept a plea deal, which is going to perpetuate this cycle of going in and out of jail, not finding a job. Then you're stuck with no money, and that it just perpetuates the cycle. So in a perfect world, that's what it would be. But I also believe that it would have been extremely helpful to know my rights. So for me as an advocate and in the community, participatory defense is really important in educating the community on what they should expect if they were to come into contact with the law. And so when they do go to court, they know if they're getting a good deal or getting the services that they should be getting. So that's what I believe.
Thank you, Maggie. And I should say I'm going in alphabetical order here, my last name here. And so after Maggie comes Adiola.
Thanks, Professor Davies. So yes, I think what Maggie said when she began is sort of what I've been thinking about, right? Potentially working myself into obsolescence where, this is not the job that I do. And the system as we know it, the criminal legal system as we know it, really the legal systems where it concerns, folks who are, as we say, indigent, look nothing like their current selves. It's a future that I think is something that needs to be imagined, because I don't think we've seen it in this country. And I don't think, it is something that is going to, come without some work. So it's not just dreams, right? It's actually taking a look at the drivers of contact with the criminal legal system, to the extent that those drivers include structural racism, poverty, general inequity that is built into, our societal structure. We need to do the deep digging and ask the tough questions. I think to really get at a sense of like what we would like to see 20 years from now when it comes to public defense. To the extent that, Maggie mentions restorative justice, right? The question of, what are we as a society? What are we as a community, right? The people trying to achieve. Those who face criminal accusations are neighbors, are coworkers, they are parents, mothers, fathers, friends, congregation members. And so, there's a reason why cases are brought in the name of, the people or the state. Because the question of what the outcome should be is a question for every one of us. And it's not a question, and the outcome of that answer, the decisions that are made on those answers are not going to be borne only by the people who are, currently in contact with the system. It's going to be borne by all of us, right? I think in this time that we're living in with a global pandemic, one thing we have seen that, there are, limits to the ways in which like we can separate each other from each other, right? We are all interconnected deeply. And so the question of what the future of indigent defense looks like 20 years from now, I think starts with the actions we take today to really question, like, what does justice mean for all of us? And so, I'm delighted to be on this panel and to have, Maggie as a directly impacted person, as a directly impacted leader in this conversation, because I think, the future will really turn on deep listening to folks who have been directly impacted by these systems to help us see our way to a new future and to see our way to, the other side of, what has been erected so far.
Thank you, Adiola. What about you, Joe?
Yes, thank you, Professor Davies. I am 2 months into the creation of a 7-county rural public defender office. And the theme that we keep hearing here is that what we are trying to affect in this sort of central part of Texas, really the cusp of West Texas, is a set of policies and procedures that were put into place about 30 or 40 years ago. So when I forecast ahead 20 years, I feel optimism in some areas and some sense of pessimism to the degree that we're inevitably going to be dealing with a great deal of bureaucracy and inertia. But that's sort of not. We're also dealing with, I think, as a rural practitioner, our offices are very much on islands. We enter communities. What's in place is different county by county. What people are used to, what the expectations are, the funding mechanisms have changed, and they will continue to change. And the identity of Texas. I mean, what it means to be in rural Texas is something that will fundamentally change over the next 20 years as well. 4.5 million people moved here over the last decade, and I think that's the greatest percentage growth numbers-wise as well across the country. 85% of the population lives within 25 metropolitan areas. San Angelo, where I live, is one of the largest cities in the country that doesn't have an interstate running through it. And I really believe that what it means to be rural and what it means, how our lives and practices and how the politics of those areas will be affected by the increasing demographic change across the state is going to have a profound impact on what it means to be a rural practitioner in this state. Even looking at the Legislative Council, Texas Legislative Council, I believe 18 different state agencies have their own definition of what rural means. The opportunity, and it might sound a little abstract, I think lies in a tremendous amount of good work. Again, this is on the rural front that has been done well before my time. And I think that that is going to be creating a shared vision for what it means to be a rural defender across the state of Texas, so that there isn't a recreation of practices and policies and procedures every single time there is a newly funded entity that comes to assist with public defense in whatever series of counties is covered by whatever indigent defense plan. And anytime you talk about visions, I can sound pretty vague and abstract, and I understand that, but I do think that a huge recognition that is okay and to understand is that rural Texas actually does operate in a slightly different manner. And I think it's okay to understand that what we might be focusing over the next 20 years might be on the receiving end of some different forces that are at play across the state and are playing out around us as the demographics change and as Texas as an identity changes. So what I look forward to over the next 20 years is working with people more experienced and smarter than myself to really create the blueprint and playbook forward to how to sort of create a higher level of solidarity and efficiency in shifting this practice forward, so that it doesn't sort of feel like it's a bunch of disparately operated parts, but that we are somehow conjoined into a collective whole with a very shared mission.
Thank you, Joe. I want to pass it to Amanda. And Amanda, when I introduced you, I failed to mention your work in public defense. I failed to mention your advocacy around the creation of the Travis County Public Defender and your work in Harris County. So I apologize, it may not have been obvious, your connection to the field, but please go ahead. I'm sure you'll correct that momentarily.
Thank you for that. It's great to be on here with all of you talking about the future of public defense in Texas. I kind of was thinking about three different visions that I think really come out of values that are being put into practice on the ground right now. So I liked that we ended the section on present public defense in Texas with Annette Price, who really is doing the work of articulating a vision today of what public defense should look like in 20 years. So she really created a great segue. And same Maggie with something you said. So I think that oversight is something that needs to be absolutely transformed in public defense in Texas. And I think 20 years gives us a good time frame to do that. Even sooner would be better. What I envision is systems that are really overseen by the people who they're meant to serve, and not the people who have conflicting interests at stake. So the folks who are directly affected by, who will be receiving the services of a public defender office, their families and their communities, are the ones who public defenders are really accountable to and who are overseeing the system. The corollary of that, of course, is that judges are no longer the ones who are overseeing public defense in Texas. That is an artifact, really, at this point. Texas is way behind in the way that we're structuring public defense, in a way that judges have so much control and power, from the composition of the TIDC board to the county level decision-making around what structures of public defense look like, to individual judges who are appointing attorneys from the bench. Commissioner Ellis, in the very beginning of today, gestured towards a study that was published just a year or two ago that showed that when defense attorneys in Harris County donate to judges' campaigns, they get more appointments. That's straight up corruption. Let's just call it what it is. And so we really need to change the structure of how appointments are made, how defense systems are structured, and who has say over all of this. And that means transferring power, really, from judges to people who are directly affected. Other folks have also noted that independence is the #1 principle of public defense under the APA's principle. So involved, who themselves are players within the same systems with their own interests that are not the interests of the clients, really is a conflict that is untenable right now. The second vision is the system is smaller. And this is in contradiction to some things that people have rightly pointed out, which is that we need more funding for public defense in Texas. We have lagged behind. In truth, it should be on par with the funding that prosecutors are getting. And it's lagged behind for decades. But when I say the system is smaller, what I mean is that today we're seeing, at TFDP, we have interns almost every semester and every summer, people who are going into public defense right now, and young public defenders especially, are abolitionist in their views, in their vision. And what that means is they recognize that the legal system is inherently unjust and racist, and that it grew out of chattel slavery, convict leasing. And that what needs to happen is we need to articulate and create new systems of justice and accountability that are not rooted in this racist history and injustice. And so I'm excited to be thinking about in the next 20 years, what it will look like for public defenders to bring an abolitionist vision to public defense. And I think a lot of what we've heard from Maggie and Annette is really that vision. And so it will change the look of what public defender advocacy looks like, both on a client level and on a systems level. And finally, the kind of third thought I had for a vision of what public defense looks like is that most people in Texas who need appointed counsel are represented by public defenders, and there is a more unified system for oversight and accountability. And that doesn't mean that you don't have different county public defender offices doing different things and responding to their specific communities. Centralized funding, support, and oversight that really helps create, I think, a more widespread culture of accountability and also training and robust funding. And then what that would look like is you really had more of like a conflicts counsel model that would be for private defense attorneys or appointed attorneys, but you'd really be using the public defender structure as the way to provide public defense. Numerous people today have pointed out that there have been probably a dozen studies showing the differences between outcomes when someone is represented by a public defender versus someone who's a private appointed counsel, and that has everything to do with funding to culture to structure. So those were kind of the three visions that I came up with.
Thank you all. I've been making notes, and I think we've got some things to talk about. I love the scope of these visions, and I really appreciate the everybody's contribution. I do want to move on to asking what the role of the government is to realize these visions, but the first person I would like to go back to is you, Maggie. And the reason is that while we are discussing these kinds of slightly abstracted things like, the governing structures and who's accountable to whom and things like that, what we're really trying to talk about, but talking about indirectly often, is a system where there are still holes, notwithstanding the progress that has been made in the last 20 years, still deficiencies, still things that need to be transformed. And I'm not even summing up very well at this moment, because as Amanda just pointed out, perhaps a system that needs to be smaller, look totally different. But you mentioned, Maggie, that you were concerned with a specific thing that was missing in your experience, which was you wished that there was a moment when you had no rights. And I'd like to ask just to expand a little bit more on that, as much as you would like to, because what I want to root the conversation in is, what is the actual problem that a person going through the system experiences that we are trying to fix, before we start to talk about the government and funding and all these sort of, distally related issues.
So yes, thank you for that. When I first started going in the system, I was realizing that there were people in the same holding cell with different colored skin, worse charges than me, and getting in and out. And so, but in my belief, my inherent belief was that the system was there to help you. It's there for a reason. It's supposed to work, So it didn't really dawn on me until later in the process that there's a reason I'm getting this treatment and somebody else is getting out because they have money for an attorney. Now, I didn't even know what an indigent defense was. I didn't know what court appointed was. I didn't know what public defenders were. I didn't know any of that. And I remember one time I went to court and I asked my attorney if he could just pull the cameras to see that I was not there. And he says, this isn't CSI. So, I mean, I was just like, okay, well, now I feel like I'm stupid, so I don't want to ask you any other questions, you know? So, but I didn't know my rights. So I didn't know that I had a right to hire my attorney, these things. And so, and the people who did know were able to get out or to get their cases lowered or whatever, things that I didn't know. And in fact, I saw this one girl, she was leaving with a 1244A. I didn't know what that was. And we had the same charge. And so I went to my attorney and I said, can you see if I can get a 1244A? And she looked at me and said, what makes you think that you're even eligible for that? Like, and so I didn't even know what it was. And then I didn't want to ask any more questions because I was talked to like an idiot. So I think that's a deep-rooted issue, is the us and them mentality. Like, people incarcerated, the only difference between us and them, me and you, is I got caught. You know, I sat in jail with people who should not have been there. And I've been in the free world with people who should be in jail. So, I mean, this mentality of you're sitting there in a jumpsuit because you're bad, so I have to talk to you like you're trash. That mentality is so deep rooted that people don't even notice that they're doing it, you know? And so I think that, and in my naive belief that they were there to help me, and so it must have been something I did to make my sentence 3 times as long as this girl's sentence, you know? And so I think that is like the root of all of it.
Thank you, Maggie. I want to acknowledge that I'm hearing you talk about mentality and things that it might almost seem like it's difficult to root out and change. But again, we are talking about 20 years in the future. And I think that what I heard from Joe and Adiola and Amanda was a desire for transformative change, a system that doesn't even look the same, a system that's not even intended to do what it is intended to do right now. And perhaps this is a question especially for Adiola and Joe first, because you guys are working in local government contexts, and so you're aware probably acutely of the ways that those governments make their decisions. Joe, you referenced bureaucracy and inertia at one point. But Joe, you also apologized at one point for being too abstracted in your goals, and I thought that apology was not required, because and this is true of everybody on the panel. We are talking about a revisioning of the system. So bearing in mind, though, that we're talking about a system that would be unrecognizable to us today in some ways, I want to ask, I suppose I'll stick with the same order and go with you, Adiola, first. What would the role of a government be is my big question, but I actually want to put another spin on it, which will speak to issues that I'm sure you realize are in the background. You work in a local government context. At the same time, just like where I work in New York, there is a state organization that is given a role, I would say a limited oversight and funding role at the moment. While there are real strengths to local government control of all kinds of services, there are arguably also additional strengths that could be brought on a lot for a state government entity. And so when I ask the question, you know, what could the government do to realize the vision that you had, Adiola, I also would be interested in whether you think there's a special role for state government to play that it's not able to play at the moment?
Sure, thanks. I think, to the extent that, we're getting into specifics, moving away from the abstract, right? If we look at the current composition, and I think Amanda, referenced this in her opening remarks, of the Indigent Defense Commission and who is appointed, right, to make the decisions, right? The question of, are directly impacted people given access to that space, right? To the extent that it will be making decisions at the state level, thinking through, right, the composition of who are the experts. As lawyers, right, we have, very formalistic legal training. I will not get into, how a lot of this should start from, reimagining legal education and the ways that lawyers are trained and told that we are the experts, as opposed to being service providers that hold knowledge that should be given to people with experience and collaborated with in a sort of like joint conversation amongst people with equal and relevant pieces of information when it comes to problem solving. But I think creating space on something like the Indigent Defense Commission to have appointments for directly impacted community members. I served on the Virginia Indigent Defense Commission. There were no directly impacted community members on that body. That is just not something that to date has been seen as important. And I think, what we realize is there's something being lost in translation. Lawyers are, going through years of training, years of schooling, and then come out and practice, and then are asked to represent people who, come from a variety of backgrounds. And are you able to actually explain the basic concepts of what you're doing and how you are working for someone in a way that they feel heard and seen, and that they understand you are working with them and for them to help them reach an outcome that is, based in their expressed interest, right? That is the role of the criminal defense lawyer, to learn, to understand, and work in the expressed interest of their client. It's not the best interest. And so being able to actually reach those goals that are in the express interest of the client requires just the ability to communicate. So if we're talking about what can, the state do, one thing the state can do is, think about the sources of experts and expertise for something like the Indigent Defense Commission in terms of, who can be a member of it to guide subsequent policy and decision-making around funding, to the extent that, we've raised in the prior panels that the funding for state level indigent defense currently is borne by those who are indigent, right? The question there is were indigent people ever consulted about that? To the extent that, that decision-making, I think, comes from a place where people may not actually understand, right? What is to be burdened by fines and fees and how that affects your day-to-day, your ability to live a happy, healthy, whole life day-to-day, puts us just in another space, adds another dimension to what, the realm of possibility is for decision-making. On the opposite side of that, if not only having more people who are directly impacted, be on the commissions and help guide decision-making at the state level, ensuring that whenever decisions are made, there's robust, or there's adequate space for robust public input before decisions get made at the state level is, a path forward. To the extent that, we talk about, administrative processes and making sure there's notice and opportunity for people to be heard, right? That should hold true with respect to, decision-making for bodies like an Indigent Defense Commission, and giving space as it's making decisions about funding, what it will fund, how it will use, whatever limited resources exist now before moving forward and trying to gather more resources to support indigent defense, inviting more decision makers to the table in a more open and public process, right? To the extent that, even as I sit as a, member of a local government entity, right? Thinking through the steps that I would need to take to access the bodies that make decisions that control funding, for my organization, there's a lot that goes into it. So how do those organizations create the space for them for being more transparent, being more open, being more accessible? There's a lot there for the way, these processes get decided. And there are many different experts who can be invited to the table, and not just lawyers, not just, those of us in academia, and, in traditionally recognized and funded organizations, being brought to the table to come up with a more robust set of options grounded in people's lived experiences and context for decision-making moving forward.
Thank you, Adil. A seriously thought-provoking idea about the governance of indigent defense in the state of Texas. I'm quite sure that members of TIDC are taking notes. I know I am. Joe, same question to you. What do you think that the government should be doing differently to realize this vision of indigent defense in 20 years?
Yeah, it's a great question. Before I get into that, Maggie, I just want to say it's sometimes, whatever the system looks like in 20 years, my hope is that whoever is running this office and offices around the state remember that at the end of the day, it is injecting humanity into a process that is so easy to sort of remove that from it. And your story is something that hit me. I'm an employee of Tom Green County. I'm the chief public defender of a 7-county district. And I am an employee of Tom Green County. I get paid by them the same way the sheriff does, the same way prosecutors do. And when I go and visit someone in custody, and they say sometimes, which is quite a common thing to hear, that not looking fondly upon court-appointed counsel and expressing concerns about my ability to be a real attorney and wondering whether or not in this part of the same system conspiring against them. Actually, they have they can see that I am funded by the same entity that pays, the person across the aisle and the sheriff who arrested them. I think there are different sort of theatrical things that we do right now to give us a little bit of distance between that. It's important for us in this office to have a different sort of public facing presence, a website that's different, office is different. It was important for us structurally from the outset to set things up with the county in a way that is fundamentally different from every other department. So we could, to the maximum extent possible, express that we were a different part of, we are different. We are a unique entity with different roles and responsibilities. I think that that's part one, to acknowledge that that's a truth. The second is that to be a chief public defender to the state of Texas is a process of inheritance. The position is created, and the position is created directly out of a series of conversations that begin at a county level and involve TIDC. And those predate, generally speaking, the entrance of the chief public defender. So you enter this process immediately trying to get the pulse of what preceded you, and understanding who the people are, what the conversations were, what the expectations are, what problems are trying to be solved. And generally speaking, the incentive is categorically financial. It is, we are coming here and we are saving you money because we are paying court-appointed counsel too much money. So there is a direct governmental financial incentive for us to be here, and for us not to be here immediately spikes that they need to rebudget, right? I think optimistically down the road, there would be some ability to directly sort of bypass that, engage with those discussions, to recognize what concerns exist, can be filled with the community, but to actually sort of fund and bypass the process by which a single county acts as a fiscal agent. Again, I'm a rural practitioner. This is what I'm used to. And I'm sure Adeola's forces are largely different and probably a little bit more chaotic than mine. But that is the way that Texas is, a large number of rural counties. And if these rural offices are going to be funded down the road, I do think that, referring back to the shared vision, I think part of that is an ability to have other rural practitioners around the state have some sort of input on the process, so that someone coming into a new office has an awareness of what they're walking into. And in an ideal world, it would be a separate funding mechanism altogether, but that might be another conversation entirely.
Well, we do have 20 years, and my guess is there'll be 20 years after that. But yeah, I appreciate that, Joe. And I want to make some space for Amanda also. Amanda, you already alluded to a lot of issues around governance, things like oversight, things like the roles that certain people get to play. I wonder if you have a particular view in response perhaps to what's already gone before about what you think the state ought to be doing vis-a-vis counties and in the responsibility it takes in realizing this future vision.
I think I want to largely co-sign on what Joe and Adeola have said, which is one, we need to be including people who have been directly impacted by the system in decision-making at really every level. So state and local government, but also in like the oversight boards for public defender offices. Adeola's board, I remember we fought pretty hard to have a couple people who are directly impacted on that board. And I think that that's a direction that many public defender boards are going in Texas right now, which is exciting to see. And I think also there are real structural problems with the funding and accountability and oversight of public defense right now that I've already spoken about, and I think Joe was kind of gesturing towards as well in his comments. So coming out of those, like I really see those as two of the most important transformations that need to happen in the next sooner than 20 years, but let's just say we get there by 20 years. But I think what this is bringing up is like the challenges in that are not intellectual. They have everything to do with power and money. And I just kind of want to emphasize that and what it will take for local and state governments to actually do these things, and who has the power and influence and who is acknowledged as an expert right now and who's listened to. And so I think that's really, that points to the barriers and the opportunities. And what gets me really excited is seeing folks like Maggie and others who have been impacted by the system, who are really organizing to create power that can kind of change this imbalance. Because what's so pernicious about the criminal legal system is it has disempowered through generations communities of color and people who do not have access to financial resources. That's through voter disenfranchisement, or really just the day-to-day struggle that people face that makes it really difficult for them to participate in democratic governance. Those of us who show up in the Capitol know what it takes to show up in the Capitol, which is transportation, time during the day. Some of them paid for that work. People don't get paid for that work. And so the folks who have power right now are the people who have access to like financial resources and to this existing systems of power. And that is, largely judges and criminal defense attorneys and prosecutors. That's who we think of as the players in the criminal legal system. So I just really want to point out like what kind of shift we're really talking about, what it's going to take for local and state leaders to start listening to the people who have that experience, and really to recognize the power building that's happening through organizing from people who have had experience with the criminal legal system, and really the barriers that they face with that. That's not really to add on to like more ideas, but just kind of some reflections, I think, on what it's going to take to get to these visions.
Thank you so much. Much appreciated, Amanda. We've got about 25 minutes left, and I still want to touch on our other two themes and give people a moment to sum up at the end. So I think I'll continue my regular cycle, if I may, and come back to you, Maggie. The next thing I wanted to talk about was judges. And the reason I wanted to talk about judges was, well, there are lots of reasons. But one of the most practical things that judges do is they literally decide who gets a lawyer. It's their job to decide if you're indigent or not. And one thing that you mentioned, Maggie, was that in your experience, you had a moment where you didn't even know what a public defender was. How would you, right? How would anybody really? And I wonder what that learning process was like. And I wonder if you have any particular experiences of having to ask to have a lawyer assigned to you, and how that process actually went.
So the way the first, whenever you go and to get booked and you go in front of a magistrate judge and they ask you, can you afford an attorney? If you say no, then they send you off to the side and you have to fill out this paperwork. And so, and also one thing that I want people to think about, just humanizing this process. When you're standing in front of a judge after being ripped from your home, no matter what the situation is, whatever is being said to you is not sticking, because you're thinking, what am I going to do now? If you have children, who's going to take care, and you can't get to a phone and you can't do this, So that whole experience right there is just, it kind of turns into a fuzz, a blur. And so even if they were explaining it, which they don't, but if they were at that point, it wouldn't, I don't know how successful that would be. But, and also, not just with the criminal legal system, but also in the family services, the judge doesn't ever even look up at you. And when I realized, it was like an epiphany whenever I realized that the judge has a wheel of attorneys that they use. And then you go back to look at these contributions to these campaigns, and say in the family services, these attorneys are stripping rights to parents, and the adoption agencies are donating to the campaigns of the judges. So it's such a corrupt system that it just, I don't know, years is enough to fix it, So I think it's very important. Amanda is such an inspiration, because the visions that she has just for the entire community to start thinking in an abolitionist mindset. Because just because a judge is there, and just because there's an attorney there, and just because there's a jail there, doesn't mean that the community is safe. I do not feel safe when I see a police officer. So when you talk about community safety, what community are you talking about? I pay taxes. I live in a district where I vote. And so I just think that all of these things need to be, civics is very important. We need to be taught in an early age, look, if you have any contact with law enforcement, this is what you should and should not do. Even though, I don't know, it should be common knowledge by now, especially in rural communities with children of color. And that's what I'm trying to do, is go all across Texas and just try to teach people, look, just because the justice system is there doesn't mean it's a just system. So, yeah, I think that it's just education from day one.
Thank you, Maggie. So I'll come straight to you, Adiola. I'm starting with the premise that judges are very powerful in this system, that they are a gatekeeper when it comes to access to counsel. And I want to open that for debate. Maybe I'm not right about that distinction for some reason, but it is something that I know prior to the Texas Fair Defense, we had research. We actually had surveys done of judges in the late 90s where people asked them, would you consider the fact that a person donates to your campaign when you make an assignment decision? And about a third of them were like, yeah, maybe. And then last year we had the economists go into Harris County and verify that that was exactly what was happening. They had a few suggestions. They said things like, you know, maybe if you donate to a judge's campaign, you should be off the wheel for the next year, something like that. I thought that was pretty clever. It still may be a band-aid over the problem, though. We've got a bigger issue of judges' involvement here. What do you think, Adiola? Judges as powerful people can transform this system in a positive way, maybe if they wanted to. On the other hand, maybe they should be not playing the role that they do. What's your view of it?
Yeah, I mean, I think I'll knit some of the threads that have already been put out there by Joe, Amanda, and Maggie with respect to the idea of power and independence. And I think, right, judges are elected officials to the extent that they, you know, run in elections, you know, sometimes uncontested, you know, sometimes, or I don't even say sometimes, too often uncontested, that they are able to, you know, wield power based on these sort of like unspoken or sometimes spoken, you know, quid pro quos, is deeply troubling to the extent that, you know, if we looked at sort of like the share of, you know, the voting age population that actually elects judges in any given race that is happening for, you know, a seat, one has to question, you know, the historic disenfranchisement that has happened to the communities that judges are impacting with their decision making, right? And to the extent that the answer to that is in some ways, as has already been spoken to, right, organizing by those communities to wrest back some of their ability to wield power and make judges accountable to what a community would like to see in their consideration of the law and their consideration of outcomes and their consideration of access, right, to the courts and access to counsel. You know, I think that organizing work is going on and has been going on in Travis County, and I think, or hope, only continues to grow, so that there is a redistribution of power, and that judges, you know, do not hold an outsized share of that in their ability to make decisions over others' lives, to the extent that, you know, they are one part of the system. Balance needs to be better tipped back to a righted position where the people that judges are now, you know, passing judgment upon have been able to participate in all the processes that decide who gets to sit in that seat to make those decisions and have those considerations. Something that is, you know, another piece of it, though, is sort of training, right? Judges who are elected and or appointed, you know, we have some, part of the question, I think, Professor Davies included, you know, judges, and I think you differentiated magistrates. And to the extent that, you know, magistrates are in some respects sometimes, you know, appointed, those serving in magisterial functions are appointed, right? I think, you know, a lot of the question on sort of like, what are the trainings available to judges as they step on to the bench and take their roles and make these decisions should be obviously very robust and should include training on the law, of course, but it should also include training on, you know, those pieces about the community members over whom they will preside, what their lived experiences are like, what, you know, happens, right, from their perspective in going through the legal system and standing before the judge, and what is known and what is not known. And I think really, drilling in on the training that happens, especially as the law is ever evolving and ever changing, and society is ever evolving and ever changing, making sure that our judiciary has access to the type of educational materials and programming that actually reflects, what's happening at the ground level in our country and in local communities. And there should be some ability to affect and influence sort of like what that judicial training looks like, that is, allowed to have input beyond sort of like, the traditional gatekeepers of what the judiciary is exposed to. And I know many judges independently make it, their own person, make sure that that is evenly spread across all judges, right? Each judge is individually elected here to their, particular district court or county court at law, and making sure that there's even in uniform training for judges, and really investing in that from the perspective that broadens the scope of what that training looks like. Judges too went through formalistic legal training, and now sit in their seats of power, and I think learning from the bench is great, but actually being intentional about what that training and support looks like for judges is a big question that I think is yet to be answered in full, particularly when it comes to a lens that provides deep insight to the experiences of directly impacted folks who stand before the judges.
Thank you, Adiola. Joe, do you have what do you have to add on the subject of judges' roles?
I'll keep mine a little bit brief here because I think, again, as a rural practitioner, I have 13 different judicial audiences here over 7 counties. 6 of them are county judges who are not attorneys. We have 2 county court at law judges. We have 4 district judges, and maybe for purposes of our office, the most important audience from a sort of a existence standpoint is the county judge here who has no judicial responsibilities and who also is not an attorney. So there's just a great deal of fascination that I have personally and professionally with the structure and the vested power of the judiciary itself. I think if there's a lesson in history when it comes to judges, there's a lot of inertia in that field as well. There's a tremendous amount of vested power that exists. And as a chief defender in a rural practice area, again, I think there's a big level of importance on knowing who my audience is, because as I said, it's a strange position to be in, but it's one that I have to recognize where maybe one of the more important business audiences that I have for the operation of this office is a county judge who actually does not have any judicial responsibilities. I don't know how to tweak that. I don't know how to change that. I don't know. Maybe I'm an ill match for this panel in that regard. Maybe I'm not being dreamy enough when it comes to that. But I do know that where I see it affect our clients the most, and sort of the battle that I would like to wage and have already begun waging, is specific areas where I think there is a void in us, maybe as defense lawyers, being able to really loudly advocate in very important areas for our clients, most importantly when it comes to court costs and fees. Areas like that, I think, are small ways we directly, daily in court can change the way our clients are, the disposition of their case. And I think that there are areas, and that's just an example of one, where we as practitioners can recognize who our audience is, what it is that they know, what they've been trained on, Adiola. And I think a glance at the JP training manual versus the district judge training manual, which is a very difficult thing to even get your hands on, suggests that there are differences in how these issues are being addressed behind the bench. So there is no uniformity there. And I think from our point of view, from my point of view, those are the areas that we're trying to zero in on and understand where we can affect judicial behavior, I think, on a day-to-day basis every single time we're in court.
Thank you, Joe. And over to you, Amanda.
Yeah, I'll just add briefly. I want to distinguish between two different roles that Texas judges currently have. One is the role that will exist as long as the system exists, and where they have enormous power in the courtroom. And I agree with the panelists who have said that training and accountability need to be things that are really brought about when it comes to like the behavior of judges in courtrooms. But then there's another role that judges have today in Texas that I think is outsized and inappropriate and breeds conflict, which is over the provision of public defense in Texas. And that's where I'd really love to focus too, is thinking about how to change that. And I think that like there are judges out there. We've worked with many judges out there on creating public defender offices who see the need for improved public defense and are willing in their role and with their power to do something about that. But I actually want them to go further than that. What I want them to do is to give up that power, to recognize that there's an inherent conflict in them having so much power over the provision of public defense and the oversight, and to say, you know what, I think this is inappropriate. And I think someone else needs to have this power. We actually saw that in Travis County, Adela, when we were creating your office. Judge Williams, Kim Williams, who is a county court at law judge, wrote a letter during that when, you know, there was a lot of back and forth between the advocates and the judges about what the office would look like, what percentage of cases it would take, what the oversight board would look like, you know, all these details that turn out to be extremely important, Adele, as you know, when you're building an office from scratch. And she basically said, I'm going to take myself out of the equation. I think it's inappropriate in my role as judge to be this involved in the decisions that are being made. And I would encourage more judges to do that, from their local county structures of public defense up to using the power that you have to go to the Capitol and tell your legislators that it's inappropriate for you to have that power, and that there need to be changes made to the law and what that structure looks like.
Thank you. So we've covered so much and we're coming to the end. What I would like to do is ask one more question to Maggie, and then I'll open it to the whole panel for thoughts of anybody who wants to jump in. Maggie, if I may, the last group that I said I wanted us to talk about were the defense lawyers themselves and the services that they deliver and the choices that they make in what they're doing when they deliver those services. I wonder if, based on your experience or the experience of others that you've spoken with, do you have an answer to the question, if defense lawyers did one thing differently, it would be this thing?
Humanizing their clients. And one thing that I remember sitting and just thinking, that does this person care that I have a family out there? And there was an officer who arrested me and I got a charge, and the same attorney that told me this isn't CSI. So that was another felony. And then I had to go back to my job and say that I caught a felony for this thing that really I didn't do, but I've done so many other things that you're not going to believe that. So, but when I saw the officer come in, because I was working at a restaurant and he came in, and I told him, hey, I got a felony for that. And he's like, oh, really? It's like, I got charged. And he was like, oh, well, you shouldn't have been where you were. And so I say that to say that humanizing, realizing that I'm a person, you know, and I understand you got a win under your belt, but it was at what expense, you know? And it just humanizing the fact that the people that you are dealing with are scared. They have families. They have, it's just like a blur when you go in there. You don't, it's like, what is happening? And so realizing where that person is and asking them, you know, how can I make this easier for you? Because you're out in the world, you know, we have no power if we're sitting in jail. And then also, I think asking, how can you help explain the situation? You know, I don't know how that would work, but, you know, just making sure that, look, this is your options, and thinking about that person as a person who is going to be in your community in the future. You are going to be my neighbor, my daughter's neighbor, my cousin's neighbor. You're going to be in the community. So just as much as that person wants to succeed, I think you should want that person to succeed in the same manner. If that makes sense.
Yes, thank you, Maggie. We have 3 minutes left. So what I want to do is ask the other three panelists if there's any point that they wish we had spent a little bit more time on, that they want to take a second to add re-emphasis on right at the end here. And let's just do a minute each. Adiola, can I ask, what are your kind of parting words? What's the burning issue that's still on your mind?
Yeah, I would challenge every indigent defense attorney, if we're talking about defenders, to practice as holistically as possible, right? To Maggie's point about, you know, our clients are human beings, and the ways in which that arrest destabilizes their lives, regardless of the outcome, is something that I think, you know, we need to really be honed in on, right? We've been taught to play a very narrow role in what is really a spectacle of criminal processing. Stand up, say a few words, make sure your client has looked at a piece of paper, and then keep it moving. But, you know, there's so much after that case ends and so much before it that has brought that into your life. So practicing holistically, where you actively try to assess, right, the different issues that your client is contending with when they are charged with a crime in the first instance, working to understand the importance of those issues to your client, to that human being, to that mother, to that father that you are representing, ensuring that that person can fully benefit from the expertise of any other professionals, right? Collaborate with other professionals, social workers, other attorneys trained in immigration law, housing law, family law, advocates who can help people access and go through the bureaucratic labyrinths that are some of these social service agencies, is really, you know, a way to push back against the process being so punishing while we are in, you know, the throes of the battle, larger issue, moving us to the place where we realize that transformational change of the systems. It's like transforming the day-to-day experience, day in, day out, of the men and the women and the children who are, you know, having to live in these criminal courthouses that are empty, but for the accused and their lawyers, and making sure like that space isn't a space that is as punishing as it has been. And not being afraid to speak truth to power about how the process is the punishment, and how, you know, regardless of outcome, our clients will still like need to live on the other side of this case. And we need to do everything in our power to make sure they can live happily, healthily, whole lives on the other side of that.
Thank you, Adiola. Joe, very briefly, what's the one thing that you wish we could talk about more?
I know this has been very focused on public defender offices. I would love to encourage indigent counsel who are not part of public defender offices who receive court appointments to collaborate, reach out to connect with PD offices in their area if they need for resources, advice, workshopping ideas. I'd also like to recognize that even though there is a tremendous amount of work to do, I feel very fortunate as a solo practitioner to acknowledge some of the wonderful people around the state who have continued, who do brilliant work and go very unheralded. And whether that's someone like Janie Myessie, who has really guided our office on court costs, or one of a hero of mine, James McDermott out in Far West Texas, who I think runs what I consider to be one of the tip-top public defender offices in the state. There are good people doing tremendous work, and Texas should not be a place where we send our young lawyers elsewhere to do this kind of work. They can stay here, plenty of opportunity for it. And that's my plug for rural public defense in Texas.
And what's the one thing you would like to leave us with?
I think first I'd like to just recognize that I'm not a public defender. Being a public defender, part of why I'm not is I see it as one of the hardest, weightiest jobs that a lawyer can have. And I choose to support public defense and public defenders rather than be in that role because it is so serious. And you are the person standing between a cage and freedom, life or death, being with your family or being separated from your family. The work is extremely heavy and hard. And with that being said, the defenders who I see really connecting with their clients and getting the best outcomes are the ones who approach it with solidarity and humility. And those are the two things I think I would encourage people to approach public defense with.
Thank you so much to all of our panelists. I really, really have appreciated it. I knew I would, and it's been absolutely delightful. Thank you for your time. Thank you for your thoughts. Thank you for your experience. Thank you for your focus. And thank you to our audience for their attention. Thank you to our hosts today. I will hand it back over to TIDC.
Thank you so much. And thank you all to our panelists. And if you'll turn your video off, I'll take you back down to the attendance room and I will hand it off here to Nate, who's just joined us here.
Hey everybody, I have the distinct pleasure of doing the final interactive event for everybody. It will be brief, but it should be fun. We're going to sort of look back a little bit and then I want to get people's thoughts for the future. So I think, yeah, Kathleen's pulling us up here. So go back to your poll everywhere. Olivia has dropped a link for us, which is great. So we're going to bring up the first, we're going to look back after hearing people talk about the past and the present. We would love to see what people think about where Texas has improved the most in the last 20 years. So yeah, go ahead and put in your responses. This one, I believe you could text into also. So our text in people, please feel free to do that as well. We'll give folks maybe another 15, 20 seconds to put in your thoughts. And yeah, you can choose, I think, more than one if you think there are multiple places that we've made a lot of improvement. Folks can do that. And I think I'll tee up the next exercise while people are sort of putting in their final thoughts. It looks like data is sort of the leader, but not necessarily a runaway. People are also noticing that there's been more funding. Looks like people are talking about quality and appointment rates as having improved some. So I think what we're going to do next is talk a little bit about the future. And one of the things about these kinds of events is I think it tends to bring the leaders and visionaries to these kinds of things. It's a self-selecting audience. And so having heard people talk about where we've been, where we are, some thoughts on where we should be going, what we're going to do next is an exercise to get people's thoughts on where Texas should focus on improving over the next 20 years. So you have an opportunity to enter your thoughts, and then as people enter them, you'll be able to vote on them. You'll be able to upvote or I think downvote things, and we'll sort of collectively think up some about what priorities we should be thinking about over the next 20 years. If you see something pop up here that you also think should be in there, please don't also type it in as a response and hit enter. Please just vote on it because we're gonna try to not have multiple of the same entry pop up and have people, have the same thing competing against itself for votes. If you're in this is an exercise that only our Poll Everywhere folks online will be able to do, but it looks like we now have, you might have to refresh by clicking on you might get a little yellow bar that says there are more responses in, but but please just take a couple minutes to think, enter a response if there's something you don't see in here that you think should be really focused on, and put in some votes for what you think we should focus on.
And if it's okay to jump in here, not everything will be on the screen. We've been lucky enough to still have almost all the folks we started with. So there's a ton of great ideas, and I'll do the best I can to get everything that's submitted without duplicates. But just in case you don't see what you posted, I'm working hard to get as many as I can on the screen.
Yeah, thanks for that, Kathleen. And I think we're doing this exercise for a couple of reasons. One, that we'd love to see people's thoughts, and we're excited to know what people's takeaway points from this are. We're also doing this to sort of prime our audience to think some about where we should be going in the future. When this event ends, you're going to get a request to fill out a very brief survey. When I say very brief, I mean I think it's 4 questions. And that'll be an opportunity for people to identify if any of these or other things are things that you plan on working to improve either in your personal practice or in your region or statewide. Those will be things that if you want to work on those things and want to be connected with other people who are similarly trying to do that work, we'll have an opportunity for people to share contact information, identify the kinds of issues that they hope to work on, and get people connected with other folks that are interested in doing similar work throughout the state. So I know many folks participating here already know each other, but we're hopeful that there will be some more people who y'all can meet with either in your area, in your region, or statewide. So I think it looks like we have a lot of people voting for, and we have a bunch of really good ideas, which is a lot of fun. So yeah, I think we'll just give it maybe 20 more seconds for people, and then I want to bring in Andrea and Jeff to close us out and give their final remarks, and thank everyone for your participation and joining us for this important commemoration of a bill that we feel was really important.
It should be live for anyone to, I did accidentally close it for a minute, but it should be live right now if anyone wants to get in their last little votes. And thanks everyone for rolling with this new technology. We've never actually used it, so it was pretty great that everyone jumped on and was really open to trying new things.
I just want to take this opportunity to thank everyone who attended today for your attention. I also want to thank the people who worked with the State Bar Committee and Texas Law to help plan this conference, including TIDC and Texas Fair Defense Project. I especially want to thank Kathleen Casey Gomez for doing some crazy work on the Zoom webinar back end today. We couldn't have done it without her. And thank you. And I put the CLE code in the chat, and I will hand it off to Jeff for a final goodbye.
Thank you, Andrea. Thank you all for spending time with us today. Man, it's been pretty cool. We started off with well over 150 people here, and we're ending with over 150 people here. So thanks for sticking it out with us. And I know you all spent a lot of time on Zoom, but man, this is an important thing. I think it's good to remember how much progress we've made and that change is possible for Texas Public Defense, because it's happened, and hopefully will continue to happen with your help. So thanks for being with us. And yeah, just to second that, thank you, Kathleen, for all the good work you did today. Thanks to Andrea, thanks to Nate, thanks to Amanda Woog for helping plan, and hopefully we'll see and talk to you all soon.